Board's back in session. We're on agenda item number 9. This is the time and place for a public hearing to consider an administrative civil liability order for Baldev and Camel Abarth of Fresno County. Designated parties for this proceedings are as follows: the Board's Prosecution Team and Baldev and Camel Abarth. All other parties are considered interested persons. In November 2016, a hearing panel of the Board considered an Acl complaint issued by the Board's Prosecution Team. After receiving evidence and testimony, the hearing panel adopted a recommendation that the Board issue an Acl order at a subsequent meeting. The Board will now consider the hearing panel's recommendation. Though the Board will not be accepting new evidence, the Board will allow designated parties and interested persons to make brief policy statements. These policy statements may not, and let me emphasize not, be used to introduce new evidence. The following time limits will apply to the policy statement presentations. First of all, on introducing new evidence, I'm sure that our attorneys will be notifying us if that is occurring. That's something we have to ensure against. So the time allocations are the Board Prosecution Team 3 minutes, Baldev and Camel Abarth 3 minutes, and all interested persons 3 minutes. And as is our policy, a timer will be used. All persons expecting to testify, please stand at this time. Raise your right hand and take the following oath. Do you swear the statement you're about to give is the truth? If so, answer, I do. Thank you. The order of this hearing is as follows. The Board's advisory team will give a short presentation describing the hearing panel recommendation. The prosecution team, Baldev and Camel Abarth, and interested persons will then be permitted to make their brief statements. Please state your name, address, and affiliation, and whether you've taken the oath before you testify. If you haven't submitted a speaker card yet, now's the time to submit one to Ms. LaFranca Rosardi, who will be sitting over here to my right. Does Regional Board Advisory Team Council have any legal issues to discuss at this time?
No, Dr. Longley.
Thank you. Are there any procedural issues that the designated parties would like to discuss at this time?
Good afternoon. My name is Susie Loskatoff. I'm the counsel for the prosecution team, and we have a motion pending objecting to the introduction of new evidence and legal argument that's currently pending that we were hoping for a ruling on before we begin.
Just so I'm clear on what you're referring to, this is the objection to introducing the comment letter that was submitted?
Yes, that's correct. And there was a letter submitted by the dischargers, and the prosecution team objects to its admission into the record as new evidence and legal argument, and it also included a confidential settlement communication that we request to have stricken from the record.
I believe the board chair ruled on that. I'm trying to find it just to confirm. I'll just need a minute.
As I recall, I did rule on that, but if you can find it, that would help. And if I ruled it, my ruling stands.
It appears we're not able to find it. Dr. Lally, I might suggest that the board take a 5-minute recess just to
Yes, and I may have something here.
Okay.
We'll take a 5-minute recess while we locate the document. No, this goes way back. That's earlier. Did you found it, Andrew?
Are we back in session?
We're back in session.
Okay. So the board chair did rule on admitting the comment letter, including the evidence, and this is my fault. I didn't transmit the ruling, so if the board chair would like to affirm his prior ruling.
I will affirm my prior ruling.
Okay, thank you.
Thank you. So we'll take, at this point, testimony from prosecution team. Pardon?
Would you
No.
elaborate what the ruling happened?
Yeah,
to
you need to elaborate on the ruling, Andrew.
So the document in question was a letter transmitted January 25th, 2017. The board ruled to accept this, or the board chair ruled to accept this into the record.
Counsel, I didn't know how this was going to proceed because these are some of the cases we had received. So is this a letter that has already been presented to the staff?
It has been presented to you, yes, and posted on the website. That's correct. And again,
I didn't-
the mistake was
Got it.
that we apparently did not transmit the ruling itself to the prosecution team and the discharger. So the document has been provided to the board.
Okay, I didn't know if we were supposed to look at it because it's new evidence, but we should.
It's already in your files, yes.
Very good.
Okay. Are we starting with the presentation or the?
We're starting with a presentation, and the presenter just arrived.
Hi, this is Clay Rogers. I'm Assistant Executive Officer for the Fresno office.
Hold on one second. Where the advisory team is going to do it at the first presentation on these to key up the items, unless you would like to just not have just a short presentation on keying up the items.
Did we need it on this one? It wasn't
Well-
one of the issues where we're concerned about consistency.
We have the advisory team has a prepared presentation for all of these items to refresh the board's, to
Okay.
explain to the board the decision that was reached by the hearing panel. I suggest that the board allow the advisory team to give their brief summation of what was decided at the hearing panel and essentially what is before the board for its consideration today.
Okay, we'll do that.
Sorry, Dr. Long, your hearing procedures didn't include that in there.
Yeah,
so-
I know. I read rotely, you know. Go ahead, Adam.
Okay. Good afternoon, Mr. Chair and members of the board. My name is Adam Lapitz, Assistant Executive Officer here in the Rancho Cordova office. I'm on the advisory team. I have taken the oath. Today I'm going to just provide a really brief summary of the proposed panel recommendation for administrative civil liability for Baldev and Camel Bath. The baths own approximately 289 irrigated agricultural acres. Field inspections found evidence of commercial irrigation. The alleged violation is failure to obtain regulatory coverage for discharges from their irrigated lands. In summary, the Kings Coalition enrollment deadline was May of 2014. Because they had not enrolled, 13260 directives were sent in March 2015 and May 2015 that required coverage for them to obtain coverage for their discharges from their irrigated agricultural lands. They enrolled in the Kings River Water Quality Coalition in July of 2016, and there was an administrative civil liability complaint issued in August of 2016. For calculation of penalties, the maximum liability amount is $473,000. This is from a total number of days of violation of 473 days. This is a total number of days from the issuance of the 13260 directive, not from the enrollment period under the coalition order. Using the enforcement policies approach, they collapsed the days to 30 days with a proposed liability amount of $35,940. The hearing panel, after considering the record and considering testimony, recommended that the board assess administrative civil liability in the amount of $35,490. The panel vote was yes for all board members present.
Thank you. We're ready now for your presentation, Mr. Rogers.
Hi, this is Clay Rogers, Assistant Executive Officer for the Fresno office. First of all, I would ask, since the letter from the Baths was accepted into the record, we were not aware of that as the prosecution team, as we were not informed that had been ruled on by the chair. But our legal staff from Office of Enforcement submitted a response letter on January 30th. We would like to confirm that that was accepted into the record, or request that it is accepted into the record because it responds to the comments that were included in the letter from the Baths attorney.
So we received you're referring to the prosecution team's motion to exclude the new evidence?
That is correct.
Because it was styled as a motion and not as an evidence submission, we weren't aware that it was required to be admitted as an evidentiary submission. But at this time, the board chair certainly can entertain a motion to have that submission admitted to the record.
We would request that that be so.
Do we have copies of their submission?
We can print out several for the board members and advisory team.
Let's see it before I rule.
We're gonna have to pause this one and come back to it in that case. Andrew, I would suggest that we pause this item, table it for consideration right now, have the copies printed, and then resume consideration of this ACL perhaps after the board considers other ACLs that are on its agenda for today.
Okay, I hope we can proceed a little smoother than this for the next ones. Do I have a motion to table?
I would move that we continue this item or trail this item until after.
We'll hear it today, once we get the information. Right, do I have a second to that?
Yeah.
Very good. We don't have anybody here to call the roll.
Sorry, Dr. Longley. Dr. Markham?
Aye.
Member Snyder?
Aye.
Denise Gadara? John Cosentino?
Aye.
Carmen Ramirez? Raji Brar? And Dr. Longley?
Aye, motion is tabled until we come back with all the printed information we need. With that, we'll proceed to item number 10. This is the item of Alex and Vera Kovitz. The time and place for a public hearing to consider an administrative civil liability order for Alex and Vera Kovitz of Fresno County. The designated parties for this proceeding are as follows: the board's prosecution team and Alex and Vera Kovitz. All other parties are considered interested persons. On November 2016, a hearing panel of the board considered an ACL complaint issued by the board's prosecution team. After receiving evidence and testimony, the hearing panel adopted a recommendation that the board issue an ACL order at a subsequent meeting. The board will now consider the hearing panel's recommendation. Though the board will not be accepting new evidence, the board will allow designated parties and interested persons to make brief policy statements. These policy statements may not be used to introduce new evidence. Following time limits will apply to the policy statement presentations. We'll start off with a short discussion by the advisory team, and then the board prosecution team will have 3 minutes. Alex and Vera Kovitz will have 3 minutes. All the interested persons will have 3 minutes, and a timer will be used. All persons expecting to testify, please stand at this time. Raise your right hand and take the following oath. Do you swear the testimony you're about to give is the truth? If so, answer, I do. Thank you. The order of this hearing is as follows. The board advisory team will give a short presentation describing the hearing panel's recommendation. Then the prosecution team, Alex and Vera Kovitz, and interested persons will then be permitted to make their brief statements. Please state your name, address, affiliation, and whether you've taken the oath before testifying. If you haven't submitted a speaker card yet, now is the time to submit one. Up to the front table here, Ms. LaFranchi. Rosardi's not here, but someone will take it from you. Does the Regional Board Advisory Team Council have any legal issues to discuss at this time?
Not at this time.
Are there any procedural issues that the designated parties would like to raise? Seeing none, we'll now proceed with a brief statement by the advisory team.
Good afternoon, Mr. Chair and members of the board. My name is Adam Lapitz, Assistant Executive Officer here in the Rancho Cordova office, and I have taken the oath. I'm going to give a short summary of the hearing panel recommendations for proposed administrative civil liability for Alex and Victor Kovitz of Fresno County. Kovitz owns approximately 79 irrigated agricultural acres. Field inspections found evidence of commercial irrigation. The alleged violation is failure to obtain regulatory coverage for discharges from their irrigated lands. The King's Coalition enrollment deadline was in May of 2014. Since the dischargers had not enrolled, a 13260 directive requiring them to obtain regulatory coverage was sent to them in April of 2015. As far as enrollment goes, there's no evidence in the record indicating enrollment at this time. An ACL complaint was issued in August of 2016. The calculation of penalties, the maximum liability amount is $477,000. This is for a total days of 477 days of violation. The days were collapsed to 25 days using the enforcement policy. This results in a proposed liability amount of $26,813. After consideration of the record and testimony at the panel hearing, the hearing panel recommended reducing this amount to $10,000. And this one was reduced because of, or due to financial concerns. Mr. Kovitz had provided his crop to a packing company, and that packing company had gone bankrupt. And so there were serious concerns about him essentially not being paid several or 2 times large sums of money. In summary, the panel recommended the board approve an ACL order of $10,000, and all 3 board members present voted yes. Thank you.
Very good. We're ready now for the prosecution team.
Hi, this is Clay Rogers, Assistant Executive Officer in your Fresno office. I just have one comment to state. It is my understanding that Mr. Kovitz did get membership with the Irrigated Lands Coalition shortly before the hearing panels were set. So I do believe, I think Mr. Lapitz mentioned that, or what I heard was that they did not have coverage, and I believe they do. And so with that, prosecution team has no other comments to make.
Questions? Thank you very much. Board's now prepared to hear a statement by Alexander Rivera Kobitz. Seeing none, I have no cards here from interested persons. Is there any interested person who wishes to comment? Seeing none, we'll close the hearing. And discussion will be limited to board members and members of the advisory team. Any comments?
I'll comment only because that was on the day I was there. For those of you who don't know, some of us were there one day, some of us were there the other, and this was one of the ones on my day. I do remember this one. I don't have any reason to change where we were.
Can you give me a motion?
Sure, do pass or do adopt, do something.
Be the
So
motion.
do I not accept a motion to adopt? Do I have a second?
I'll second to do something.
Just to be clear for the record, the motion is for the full board to accept the hearing panel recommendation and issue the ACL order as proposed by the hearing panel.
And as part of your motion, do you accept that?
Yes, that's right, I meant to say.
And the second? Yes.
Yes.
Thank you very much. Call the roll, please.
Dr. Markham?
Aye.
Mr. Schneider? Mr. Costantino?
Aye.
Ms. Ramirez? Ms. Brar?
Aye.
Ms. Kadara?
Yes.
Dr. Longley?
Yes.
Motion carries.
Thank you very much. The motion is carried. We'll move on to agenda item number 11. This is the time and place for a public hearing to consider an administrative civil liability order for Gilbert and Enidina Mariquin of Tulare County. The designated parties for this proceeding are as follows: the board's prosecution team and Gilbert and Enidina Mariquin. Other parties are considered interested persons. In November 2016, a hearing panel of the board considered an ACL complaint issued by the board's prosecution team. After receiving evidence and testimony, the hearing panel adopted a recommendation that the board issue an ACL order at a subsequent meeting. The board will now consider the hearing panel's recommendation. Though the board will not be accepting new evidence, the board will allow designated parties and interested persons to make brief policy statements. These policy statements may not be used to introduce new evidence. The following time limits will apply to the policy statement presentations. Board prosecution team, 3 minutes. Gilbert and Enidina Mariquin, 3 minutes. All interested persons, 3 minutes. And as I've stated before, a timer will be used. All persons expecting to testify, please stand at this time, raise your right hand, and take the following oath. Do you swear that the statement you're about to give is the truth? If so, answer I do. Thank you. The order of this hearing is as follows. The board's advisory team will give a short presentation describing the hearing panel recommendation. The prosecution team, Gilbert and Enidina Mariquin, and interested persons will then be permitted to make their brief statements. Please state your name, address, affiliation, and whether you've taken the oath before testifying. If you haven't submitted a speaker card yet, now is the time to submit one to Ms. Lanfranchi-Rizzardi, sitting over here to my right. Does Regional Board Advisory Team Council have any legal issues to discuss at this time?
Not at this time.
Are there any procedural issues that the designated parties would like to raise? Seeing none, we'll proceed with the advisory team presentation.
Good afternoon, Mr. Chair and members of the board. My name's Adam Lapitz, Assistant Executive Officer here in the Rancho Cordova office, and I have taken the oath. I'm going to present a summary of the hearing panel recommendation for proposed administrative civil liability for Gilbert and Enidina Mariquin of Tulare County. The Mariquins own approximately 65 irrigated agricultural acres of pistachios. Field inspections found evidence of commercial irrigation. The alleged violation is failure to obtain regulatory coverage for discharges from their irrigated agricultural lands. In summary, the discharger failed to enroll. The Cahuilla Association Coalition enrollment deadline was August of 2014. because they had not enrolled, a 13260 directive was sent requiring them to obtain coverage in the Irrigated Lands Regulatory Program. And an ACL complaint was issued on August 9th of 2016. The discharger enrolled on August 10th of 2016. A calculation of penalties. The maximum liability amount is $580,000 for a total days of violation of 580 days from the issuance of the 13260 directive. The use of the alternative approach under the enforcement policy, these days were collapsed to 28 days, which resulted in a proposed liability amount of $30,030. After consideration of the record and testimony, the hearing panel recommended that the board approve an ACL order assessing $30,030, and the panel vote was yes for 2 board members and no for 1 board member. And just one aside on this one, there was a discussion that day about ability to pay, and you may hear more today from the dischargers on that issue. That is my presentation.
Thank you very much. We're ready now for a statement by the prosecution team.
Hi, this is Clay Rogers, Assistant Executive Officer from the Fresno office. Again, I really have no comments to say other than to recommend that what the hearing panel proposed be adopted. We would like to reserve the right that if new evidence is brought forward and accepted by the board and testimony by the discharger, that we would like to have the opportunity to respond to that. Thank you.
Any questions? Thank you very much. We're now ready for a statement by Gilbert and/or Indadina Mariquin.
Good afternoon, members of the board. My name is Justin Harris. I represent the Mariquins. I recognize at least 3 of you from our prior hearing in November. If you want my address, 7110 North Fresno Street, Suite 400, Fresno, California, 93720. That's where Harris Law Firm is located. I don't intend to introduce any new evidence today, simply because that's not really permitted, though there was some discussion about it at the prior hearing. I would simply note that it was our concern that in light of the various deadlines that were provided by which we were able to submit evidence to be considered at the November hearing, the financial information that we really needed in order to demonstrate the inability to pay was simply not available at that time. And so we feel some prejudice in that regard, but we won't attempt to hijack this process or otherwise deviate from it today, but simply wanted to bring that to the board's attention that that's been a real issue. I would just highlight some points. We submitted a written policy statement. The board also received, and I'm sure considered, a policy statement submitted by Senator Gene Fuller in support of the Mariquin's position. And I believe that was submitted on January 13th of 2017. Just to recap for some of the boards, the 2014 time period was very difficult for the Mariquins. Not only was he suffering from cancer, but was hopelessly in debt. The information that we would have provided, had we been given the opportunity to do so, would have demonstrated a further inability to pay, which we attempted to do with the information available to us. I would note that there, and as a matter of policy, what perplexes me, and perhaps this is simply because I'm somewhat new to this process, is that at no time, and this is in the administrative record, at no time was there any evidence of actual discharge. There was no contamination. This is simply a failure to enroll, and we believe that the board's the recommendation for the $30,030 penalty to be excessive, considering that this was a mistake unrelated and to the extent that there was no actual harm caused. we would simply ask that the board adopt either the minimum, or I think as was proposed by one of the board members, something closer to the $10,000 range, in which case, then we'll go away quietly. And with that, I'll take any questions or otherwise conclude my statement.
Are there any questions or comments by board members?
Can I ask what the land is used for?
For pistachios, there are 65 acres of pistachios.
Okay. Thank you.
Yeah, go ahead, Raji, do you have anything else?
Here it says 39.6 acres.
That has to do with the fact that there are two approximately 40-acre parcels, one of which is 39.6 acres, but the actual amount that consists of pistachios is 65, which there's been no dispute by the prosecution team on that point.
Yeah, and I believe that's accurate. Again, for the purposes of this hearing, the advisory team can be asked to explain what's in the administrative record so that we don't wind up adding more evidence into the administrative record here today and conducting a full-blown hearing. This is really just a focus on what the hearing panel recommended to the full board and whether the board wants to accept that. So we're certainly available to answer questions about what's in the record.
Great.
Dan?
Is that true that he got the ACL notice and then signed up for the coalition the next day?
He did. I'm sorry?
And again, that question would be for the advisory team since we don't want to develop further testimony at this hearing. So
Sorry, I'm used to answering whenever I hear something from that side.
give us just 1 minute and we can look for that.
Much like I'm used to reading what's in front of me.
Apparently, the record reflects that there were previous notices sent to Mr. Marroquin, which may have been disregarded, he says, because there were no discharges from his facility. As the record shows, Mr. Marroquin's understanding of the term discharge was discharge to surface waters as opposed to discharge to groundwater, which is what the WDRs are designed to regulate. So, and this was explained in the order itself and certainly in some of the documents that were provided to Mr. Marroquin in advance of the issuance of the ACL complaint. Mr. Marroquin did enroll in the coalition shortly after receiving the ACL complaint. Again, I think that that's common to many of the dischargers who are here before you today.
I would note as part of that, and this is in the record, so I'm not adding anything new, but not only did he proceed to enroll, but he went and paid any of the back enrollment stuff so that he would have otherwise been totally current at that time.
Are there any further questions or comments by board members?
So I just want to clarify with the advisory team, our options. I know there's 4 options. Can you just restate them?
Yeah, the board can here today accept the hearing panel's recommendation and adopt the ACL as proposed by the hearing panel. It can look at the evidence that's already been received into evidence and say this evidence merits a higher or lower penalty. The board, and that's option number 2. Option number 3, the board can say on the basis of the evidence that has been admitted into the record, we do not believe enforcement is warranted in this case and wholly terminate the proceeding. Or option number 4, the board can determine that the evidence is incomplete and recalendar this for another round of hearings to address more, add more evidence into the administrative record.
Dan, go ahead.
I'd like to hear a little bit more from the board members that were at the hearing. Is that possible?
Certainly.
Well, yeah, let's do that. That's a good idea. Thank you, Bob. We can discuss that after we close the hearing. Any questions or comments for the discharger at this point? Seeing none, thank you, sir.
Thank you.
And are there any interested persons who, yes,
My name is Gilbert Marquand.
Mr. Marquand
I'm
is
an-
not an interested person.
I'm not?
no,
You're a party to the proceeding.
you're a party to the
Okay, well
proceedings.
then I made a mistake. All right, thank you.
Thank you. Seeing no interested persons, we'll go ahead and close the hearing and limit discussion to the board members and members of the advisory team. Yes, I think as the advisory team, as the advisory team has stated, the three of us who were considering this had a discussion really on the ability to pay. This was not one where there was an agreement, and I think with that said, I'd like to ask Carmen if she would add to the discussion.
My recollection of this item was that it was an argument over hardship and inability to pay. I think it was undisputed that that the enrollment had happened after the ACL had been issued. I think there was some misunderstanding by the discharger as to what was expected of them in order to be compliant, and there was certainly a misunderstanding, I think, as to what a discharge was. So I think that there was misunderstanding, but where this really hinged for me was the testimony by the parties as to ability to pay. There was declarations there that they did have evidence that could support the oral testimony that they presented there that day. The evidence to back up the oral testimony was not available. And I'll let the other members speak for themselves, but I recall feeling that the testimony by the discharger was credible. I agree that the evidence to back that up was not there, but nonetheless, I thought that issuing a penalty, but in a lower amount, would have been justified for me. And I think that I made that motion, but it did not pass. And then I think the other board members were able to come to an agreement after that.
So, and if I could add to that, and certainly how I recall the proceeding going as well. If I could add to that, a lot of the discussion in the Merced hearing panel item had to do with that key issue of, does Mr. Merced have an ability to pay? There was evidence in the record that Mr. Merced had sold a parcel of property for, I believe, $2.3 million. There was also evidence in the record that for the tax year of 2013 and 2014, Mr. Merquin's business situation did not look great. The question that the board had, and certainly the issue that we were trying to develop further, was what does the picture of 2015 and possibly 2016 look like? Mr. Merquin said on the record that 2015 was a good year, but there was inconsistent testimony from Mr. Merquin about how that factored into his ability to pay. There was a limited opportunity to present evidence after the hearing panel. Essentially, the hearing procedures for this item said, the board will not be accepting new evidence unless the party submitting the evidence provides compelling justification that a serious miscarriage of justice may occur if the new evidence is not admitted into the administrative record. Requests to admit additional evidence must be submitted as soon as possible to the board's advisory team. The key piece of evidence that was missing at the hearing panel was what was the financial picture for 2015 and possibly what was the financial picture for 2016. The concern of the board being that 2013 looked bad, 2014 looked bad, but pistachios are cyclical. You have good years and you have bad years, like most crops. The concern was, based on the testimony that 2015 was a good year, we were only getting the part of the picture that showed that there was an inability to pay, And in addition, there was conflicting testimony from Mr. Marroquin about his ability to pay and double counting of certain obligations as relayed by the board's prosecution team and by Mr. Marroquin. Essentially, he submitted a document that said, I owe these debts, and then at the same time was saying, well, those debts are paid off by the $2.3 million property that I sold. So based on all that, the expert from the board's prosecution team said that this indicates an ability to pay, and that the only thing that could overcome this is possibly information from 2015 showing that the 2015 was a bad year, not a good year. 2016 showing 2016 was a bad year, not a good year. That information was not provided, despite the fact there was a limited opportunity to provide that after the hearing panel.
And if we spent a lot of time, not only on Mr. Marroquin, but some of the others on ability to pay. Was this the one where a couple of them, I know that we went into executive session. I believe this
Yes.
was one of them, and we discussed the ability to pay issue in some depth. And we came out of that, and it was a split vote. And so I think with the evidence that you have in front of you, it would be fair at this time to discuss the amount. And, you know, I'll speak for one side. I think that Mr. Marroquin has had the opportunity to provide additional information regarding the inability to pay. That information has not been forthcoming. On the other hand, Carmen has an argument on why we should accept a less amount. So would you like to add to your argument on that?
I don't know if it's necessarily an argument, but it was, I think, something that was discussed, was whether or not we should be looking at longer snapshots of income when we're considering ability to pay. And I think that went back and forth, not only on this matter, but on another matter. So I thought, as I recall, that given the inability to pay testimony by Mr., I have to say it the way I say it, Mr. Marroquin, his testimony I found was credible. I thought that I remember the expert's testimony on behalf of the state. I thought it was credible, but not fully convincing. And I thought that there should be a penalty, and I think that the penalty that I had proposed was somewhere in the $10,000 range. I would still support that today.
So we have two amounts, and I think those are the main issues, as I see them, that remain, is what the amount should be. But before we proceed on that, I would just like to say, I think on many of these items, we were confounded by not enough information over enough time period that would allow us to make more comfortable decisions on the ability to pay. With that said, let's talk about what should be a fair amount for this. And I'm sporting the 30,030. If there's some other number that we can agree upon, that would be great.
No, I don't have a different opinion on the number. I just was going to add to the amount of information we have and the ability to pay. On my day, we had several items. One of them was they had just planted crops and they were in a transition, and so we knew the future revenue should be higher than the current revenues. I'd have no idea what the cyclical nature of pistachios looks like these days. So, but I think even then, I think my point was, you have to, whatever your snapshot is, that's what you're stuck with as a regulated body. You can't base it off what you think they might earn in the future. This is a little different because we're all talking about the past. We just don't know what the number is. But without any additional data, it's hard for me to second guess what the hearing panel came up with.
And just to again, speak to Board Member Ramirez's comments. You can look at page 185 of the transcript. Board Member Ramirez was actually expressing concern as to those precise issues when the hearing panel was conducted, saying that you would be supportive of a lower amount, but that you could not convince the board of being supportive of a lower amount without that missing piece of the puzzle, without a snapshot that extended beyond the 2014 year, particularly because 2015, as was testified to, was a good year. So that without that additional information, I believe you had some reluctance to take the rest of the board in a direction south of the $30,000.
I was also at that hearing, and the issues that were concerned to me was the 2015 crop year that was very good, the $2.3 million property sold, and then just not signing up for the coalition until after. And I was really concerned about that, because if it happened the day after the ACL was issued, it could have been done prior to. And the snapshot of not having the information to give us a better picture of the financial situation, and that's not been provided to date. So therefore, I would move forward to proceed with the motion that's before us now, to keep the continue with board, not the board, but the panel's recommendation from November 3rd for $30,000.
30,000, I think it was 30,030.
30,030?
Right.
Sorry.
30,030.
So just, not to sidetrack us, but on another, in fact, on the first item where there's that supplemental letter, there was a request to pay overtime. We as the board don't take that into consideration. We let the staff handle payment plans or timing of payments?
The statute says that when we issue an ACL, it's due in 30 days, and that's the way our orders are structured. Folks who are facing administrative civil liability have been able to work out essentially deferrals from the Central Valley Board, essentially saying we're going to pay it, but give us time. And the board says, we recognize that you have a legal obligation to pay it in 30 days. We won't crack down on that legal obligation provided that you meet a certain schedule. So those agreements have been worked out in the past. It's possible that we could entertain that after this item, should the board wish to impose civil liability. But as the statute says it's payable in 30 days, our orders say it's payable in 30 days.
And so to restate that, the ability to pay is an ability to pay within 30 days. That's the metric we're looking at.
I can't comment into how the ability to pay analysis is structured for each and every item. I think in certain cases, the prosecution team's economic experts make comments as to whether they can take, say, equity positions on pieces of land that they owe, which would obviously mean that they'd be paying over time if you take a mortgage or something like that to pay your assessed liability. So again, I don't know if it means that you have liquid assets available to be paid in 30 days, just that you have the assets that you could possibly take a loan out or liquidate to make the payment.
I have a motion from Board Member Cadera. Do I have a second?
And just to clarify for the record, the motion is to accept the hearing panel's recommendation and issue the ACL order for $30,030.
I'll second it.
Dan seconds.
Let me ask one more question, sorry. This is not one of the issues, one of the cases where there was a discrepancy in the factor. I know that'll come up later. I just want to double check.
I don't believe so, but.
So there are a
Potential
couple
for harm factor or the deviation from requirement factor.
Yeah, there is a This one wound up with a .55.
Okay.
And that was generally where the board was going. The prosecution team had proposed a higher multiplier in several cases involving large farms. I think as this is not a large farm, even amongst the ACLs that are coming before the board and coming before the hearing panel, the .55 was what the board rested upon as the default number.
And I know that there's a motion, but I'll say that I did believe Mr. Marroquin's testimony at the Fresno hearing. I am disappointed that there is no further submissions that we could have relied upon here today. But it is what it is, so I appreciate the time we took today to discuss it.
I had one comment.
Yes.
I just wanted to acknowledge Senator Fuller's letter, but I wanted to point out that we're not just, talking about surface water, we're talking about groundwater protection here, and also we're talking about the integrity of this program, and that's one of the key issues. And I'm certainly amenable to, should the discharger approach the board about a little more time in a payment plan, that staff would work with him, but it's not that hard to enroll, and especially when you start getting the notices. And I think this is what the board needs to do to maintain the integrity of our irrigated lands program and support the hard work that all the coalitions have been doing.
Thank you. Any further discussion? Call the roll, please.
Ms. Brower,
No.
Ms. Ramirez,
No.
Mr. Costantino,
Aye.
Mr. Schneider, Dr. Markham,
Aye.
Ms. Kadara,
Yes.
Dr. Longley,
Yes.
motion carries.
Motion carries. We'll move on to,
Dr. Longley, we do have the printouts from the Bath item if you would like to address that.
good. So let's move back to the Bath item, agenda item number 9.
Carl, can I, while we're moving to that,
Sure.
I just want to comment on our split vote. And I think that's good that occasionally we have split votes. We're a diverse board, and we're representing our communities. And I think it isn't often that we have split votes because we really try and work these things through. But at times this is going to happen. It's nice to see that actually occurs. So thank you.
I agree. I think that, one of the fears, I think, of me as a citizen, and one of the things I'd like to assure the public of is that, we're not a rubber stamp. We're individual people with different opinions, and we try to argue our positions or carry our positions as much as we can, but we're diverse, and I certainly appreciate split votes also.
I appreciate both of your comments. That is true. I've even voted no on occasion. There we go. I have a story for you on that later. With that said, we're ready to move ahead with the reopen number 9, yes. And as I recall, we were at the issue of the prosecution team wanting us to take a letter into the record, and do we have that letter to look at?
We do. Patrick?
I think we should show it to the board members first. So what you're being handed is, it was styled as a motion to exclude a comment letter and evidence which had been submitted by the Baths after the November hearing panel. Ordinarily, a motion like this would be conducted via email, and the board chair would issue a ruling. That's kind of how we usually do it. But this document is a little bit unusual in that it includes not just reasons to exclude the evidence, but also includes legal argument about the meaning or what the evidence doesn't mean. And so in that sense, it really is a kind of a combination of an evidentiary motion and a legal argument. The counsel for the discharger was copied on this when the prosecution team sent it. And so for that reason, if the board were to admit it into the record, it's the advisory team counsel's opinion anyway that there would be no prejudice to the discharger. And so it's our recommendation that the board would admit this into the record.
So I'd like to ask counsel, before we begin addressing whether or not to allow this into the record, do you have any comments to make upon this?
At this time, I don't think I have any substantive comments.
Okay.
If there are any specific questions from the board members,
Certainly.
I'd be happy to field those.
Well, as one board member, if I'd been presented this prior to this hearing, I would have allowed it into the record, but if you don't think that that's the way to go, please.
What I was going to say is that, given that the entire, that all of the members have gotten a chance to read this already, that I don't see how we could exclude it from the record and sort of erase the impression that it's made on us. So for that reason, even though I know the chair hasn't ruled on it, I would support the chair's intent with allowing it into the record.
Is there any objection to that from any board member? We could vote on it, or I could simply rule on it. And if I rule on it, I'll take a consensus.
I would support a motion to include it in the record.
Is there anyone who is opposed to me ruling to allow this into the record? Seeing no objection, I'll go ahead and allow this into the record. Very good.
Good afternoon again, Susie Laskatoff. I'm counsel for the prosecution team. I did want to note in full disclosure, since the Baths and their attorney do not appear to be here, their attorney, Mr. Cowan, submitted a response to the prosecution team's motion on February 1st. And so I'm not going to make legal arguments on their behalf. I just wanted to make sure the board was aware that a response was submitted by the dischargers. And so I have a copy if one needs to be made for board members.
At this point in time, how did we dispose of that? Or did we dispose of it?
I don't believe we've seen that.
That's interesting.
And counsel, I don't know that always in administrative procedure, it's the same as in civil procedure, but certainly a reply to a motion isn't always permitted. Are we under any obligation to consider it here?
We are not under an obligation to consider it. I have not seen this. Andrew's double checking. It appears that they at least tried to send it to him via email, but we're going to take a quick look at it and then see how this is. And again, in front of these administrative proceedings, we generally don't adhere to the technical rules of evidence and many times give some latitude to parties who may not, even with counsel, who may not be familiar with the board's administrative proceedings. So sometimes we err on the side of letting things in that may not strictly be submitted in accordance with the hearing procedure. If I could take a look at this for just a couple minutes.
Right, this is somewhat new territory for us, so this proceedings of a panel such as this. So let me ask this question and see if it flies. If you don't see anything that's material there that you believe a value of the board, I will not admit it into the record. With the concurrence of the board, of course.
For the record, I don't believe I received this via email or any other way.
Well, you didn't receive it, so that's significant too. So unless I hear an objection, I'll deny admitting that into the, I'll deny that email or letter that you now have in your hands. I'll deny admitting it into the record. Yes, Dan?
But do they have a chance to show up? Do they know that this is the time to be here?
Yes.
Has there been an opportunity for them to say they're in a car wreck or
Yes,
something
that's
like that?
correct. That is correct. They have an opportunity to be here. As you've already seen, we've had one group show up.
And again,
Go ahead.
yeah, if I could, I would fall back again on the position that because this is a proceeding here today to consider a hearing panel recommendation, and because the hearing panel presented a full opportunity for evidentiary submittals, the bar is very high for getting something into the regional board at this very late stage. There's been multiple opportunities already. I don't see anything in this letter that pertains to something that would have happened after the hearing was conducted in Fresno. And really that's what we're trying to let folks know. If there's a tax return, say, that got completed after the hearing panel conducted their evidentiary hearing, that
Right. And then it's rather abnormal that it comes this late. The normal process is, and Patrick talked about the high bar to begin with, but normally there is a discussion that takes place between the executive officer, assistant executive officer, between the advisory team and the chair. And if I think it's something that I'm on the fence on, certainly the vice chair is included oftentimes in these discussions. And we make a decision. And at this late date, I find it really abnormal to be talking about this.
And so my recommendation, at least with respect to this letter, the February 1, 2017 letter, is that the board exclude that from consideration.
I will so rule. With that said, is there a statement by Baldev and Camel Bath? I don't believe they're here. Are there any interested persons that wish to comment?
Prosecution get to speak?
Oh, you haven't talked yet. No, you don't. Sit down.
Yeah.
I already thought, I'm sorry, Susie was up there and I took that as the prosecution team.
Just
I'll be very brief.
Just to be clear, I don't believe Adam has spoken either, so we didn't get the summary of what transpired.
He did in the beginning, I thought.
In the beginning?
He did. He corrected me that I didn't allow him to talk, and I allowed him to talk.
All these are Unfortunately, all these are running together a little bit. I don't know whether I spoke on this one or not.
I
but
didn't, I went immediately to the prosecution team, and you pointed out.
I remember pointing that out. I do remember that.
And I said, okay, and you gave your presentation. And the court reporter is shaking her head to the affirmative.
Dr. Longley, members of the board, I'm Clay Rogers, Assistant Executive Officer in your Fresno office. And I believe I took the oath
You did.
at the beginning of the first one. I just want to make a couple comments. And one, based upon the information that we submitted, based upon the new evidence that was allowed to be submitted. Item number one in the letter from the Bass attorney basically argues that the location where we had sent information to the Bass was not the correct location, that it was not a business location, that they did not receive any comments. We dealt with that issue during the panel hearing, but we should also mention that the tax returns for the Bass that had been done in the past couple of years were mailed to the address we were using. And so their argument that that is not a proper address for the Bass, but it's where their financial tax returns for their business goes, seems to argue that it is an appropriate address.
I think that the letter that Ms. Luskinoff presented to us addresses that in some detail.
It does, and I just wanted to
We got it.
point that out.
We got it.
And it also seems that the letter from counsel for the Bass also say that they're not taking issue with the fact that they're not contesting the notice issue either. So it's not really an issue.
It's not really an issue.
The other issue is the argument of an inability to pay, and it certainly appears to us that there is a strong ability to pay. These are large farmers. They farm a significant acreage of grapes and almonds, and therefore we feel that the recommendations of the panel hearing are appropriate and would recommend that the panel hearing recommendations be adopted by the full board. Thank you.
Thank you. And we've ascertained that the Baths are not here. And there are no interested persons. If I'm incorrect, please so indicate. Seeing no indication then that any of those folks are here, I'll go ahead and close the hearing and limit the discussion to the board members and members of the advisory team.
So this was, I think, the first item of the day on the first day. And the 0.55 versus 0.7 issue, I think, is relevant to this item. And so I would recommend keeping the same value except modifying it, keep the same value in theory, but modifying it based on the factor. My math comes out to $27,885 if you modify.
We have an issue here, inconsistency, and that is if you got a small farm and we got some small farms that don't enroll, are you going to make them pay as much as the large farms that don't enroll? The risk of impact to water quality is much greater, grows greater as the farm gets larger. And so my point of view on this is that for the small farms, a 0.55 may be a correct number, but that the number, that 0.75 would probably be a better number. The number's in between depending upon farm size, because impact varies. That's one of the major factors on possibility of impact to groundwater.
Yeah, and I think we sort of got into a groove, so to speak, later in the day where this was deemed the appropriate value, if I remember properly.
Well, we've had further discussion since that.
Well,
So
this was
Patrick, could you address that?
This was the first one of the day, and so this wasn't an issue at the time we
you're
passed
right.
this.
So just to be clear, and there's a number of factors that the board has to consider with each one of these ACLs, so it's very easy to get lost in some of the details here. The Bath ACL was issued with a 0.7 because they had 289 acres, which the board's prosecution team reasoned was a relatively large operation, considering all the other operations that were coming in front of the board. Now, with a moderate potential for harm and a major deviation from the requirement, which is consistent with all the others, the enforcement policy suggests a range for this one particular multiplier from a 0.4 to a 0.7. And the prosecution team essentially said 0.55 is going to be the default for all the farms, unless you're a large farm, in which case you're going to be on the 0.7 end of the spectrum. So Bath, with 289 acres, got a 0.7 as initially proposed. And then, say, Kobetz, which you just heard, with 79 acres, was a 0.55. Mariquin, again, with 65 acres, was a 0.55. So it appears around that 200-acre threshold, right around there, was when the board started going from the 0.55 to the 0.7. For a couple items later on in the day, as the hearing panels progressed, hearing the 0.55 over and over again, the hearing panels stressed maybe we should change them all to 0.55 for consistency's sake. However, there were a few of the large farms that had the 0.7, and we did wind up changing the hearing panel wound up changing 1.55 to 0.7. Legally, I think you're well within the law to go from anywhere from a 0.4 to a 0.7 based on the characteristics of this particular discharger. I think a 0.55 would be consistent, but 0.7 would also be consistent in that that's generally how the prosecution team was charging larger dischargers who arguably had a greater degree of sophistication and thereby deserved a larger end of that spectrum.
We can't do it now because we cannot talk about this consistency issue outside of this one particular discharger, but I think that at a later board meeting, we need to spend a little bit of time talking about that. Maybe tomorrow, I think we have a presentation, might be a time to also discuss that. Certainly consistency is important, but at the same time, it's my opinion that we have to look at potential to impact waters, whether they be groundwater or surface water, and certainly that risk is greater with the larger discharger. So that is why I support that number, and I can discuss that possibly tomorrow in more detail.
And I don't have all the details perfectly memorized in my head. I just remember thinking that I didn't want to be the first person up that day. And so that's why I had the 0.55 is the appropriate. If it shows that 200 is the threshold and they're large and it's consistent to go with 0.7, I wouldn't fall on my sword over it. But I just remember at the time thinking 0.55 was a more consistent number. But
I also have a comment too. It has to do with notification. Are we privy to hearing how much the coalitions made an effort to contact this person?
There is some evidence in the record. Give me just a couple minutes, and I think we can dig that up.
And I'm also going to ask a question about, strict compliance is strict compliance. But whether or not there was evidence presented that day that the Baths had made an effort to enroll and were in fact either rejected or somehow didn't enroll when they thought they were enrolling, and whether or not that was considered by the 3-board panel, and if so, to what degree is that relevant?
Dr. Markham, I just would like to point out we work with the coalitions and they do their own outreach, but all of the coalitions, all 8 of them, have made it really clear that they will not serve in an enforcement role for non-enrollment. And so they do assist us in outreach and education, but they will not, you know, at a certain point, that it falls to the board to do the enforcement needed to get the growers enrolled.
So I'm quickly seeing, and Andrew's looking up, in the initial ACL complaint, there was at least 3 communications between the board and the discharger. There appeared to be some outreach conducted by the coalition as well. We haven't tracked that number down exactly, but they are very active in conducting outreach, and the board is active in conducting outreach to the growers as well.
And there's another factor to remember here. We want people to join the coalitions. And as a grower, if I don't join, and the penalty for not joining is less than the cost of doing business correctly, then it's in my best interest not to enroll. And that certainly doesn't serve our important goal of protecting water quality. That's another reason why, for a larger grower, that I think it's imperative to send the message. If you don't join, there's a penalty to pay. And we've been, not in panel hearings like this, but in hearings before, we've been pretty severe on growers who haven't joined. And I've been told it's changed the discussion in the coffee shops the next morning. If the word gets out that well, don't join, they're not going to do anything to you. You know, you're better off from a financial standpoint, then that's not going to help our program one bit.
So, Dr. Longley, just one additional on Mr. Markham's comment. Depending on which item it is, and programmatically, some folks, we sometimes have to find these operations. So the coalition, you know, they're not in a seek out mode, and so depending on which, some of them, you know, some of them are easy to find, some of them aren't. But staff go through a lot of effort just to locate these sites, and you know, it's driving around sometimes, taking pictures, looking at satellite imagery, and so it's, you know, we think of it as someone has a list somewhere, and we're just and we're getting names on a list, but this is the building of a huge process to locate these folks. And so some of them, it might be that the board is getting them and finding them for the first time.
Oh, I agree. I could write a paper on why people don't join. You know, some of them flat out don't come to town. You know, others have a denial approach. And I just think about, you know, how to make every best effort to get them to understand what we're really about, what we're trying to do, and to get a positive spin on it so they do join.
So,
Carl, let me just weigh in. I agree with everything you said, that if cost of business is less than the compliance, or if it's cheaper to not comply, that certainly undermines the program. And I think I voted yes, that these guys should get a penalty. And I wasn't suggesting changing anything else about the penalty other than that one consistency factor. So I'm certainly going to be in favor of issuing the violation notice with the penalty amount. The question was which one.
And John, we do need to talk past this item at a time on these factors. Very good. Yes, go ahead.
Just a point of order, Chair Longley. I think we noticed in the tentative ACL order that there was a typo or discrepancy as to the amount of acreage, and based on the other submissions in the record, we're pretty sure that the correct number of acres was 289, and in the tentative ACL order, it read 320, and so I would just suggest that unless there's an objection from the prosecution team, that we go ahead and make that late change to the order.
And that can be encompassed in the motion, am I correct?
Correct.
Okay. Do I have a motion?
I so move.
And you'll also note in your motion that it was 289 acres.
Yes, 289 acres. So I move the decision that was made by the panel on November 3rd here at the hearing, $35,490.
And with the recognition that it was 289 acres.
Acres, yes.
Do I have a second to that?
I'll second that.
Bob seconded. Any further discussion? Call the roll, please.
Mr. Schneider? Dr. Markham?
Aye.
Mr. Costantino?
Aye.
Ms. Ramirez?
Yes.
Ms. Brar?
Yes.
Ms. Cordara?
Yes.
Dr. Longley?
Yes.
Motion carries.
Thank you. With that, we will move to item number 12, I believe it is. Yes. This is the time and place for a public hearing to consider an administrative civil liability order for Gurmile Carr of Madera County. The designated parties for this proceedings are as follows: the board's prosecution team and Gurmile Carr. All other parties are considered interested persons. In November 2016, a hearing panel of the board considered an ACL complaint issued by the board's prosecution team. After receiving evidence and testimony, the hearing panel adopted a recommendation that the board issue an ACL order at a subsequent meeting. The board will now consider the hearing's recommendation. Though the board will not be accepting new evidence, the board will allow designated parties and interested persons to make brief policy statements. These policy statements may not be used to introduce new evidence. The following time limits will apply to the policy statement presentations. The board prosecution team, 3 minutes. Gurmile Carr, 3 minutes. All other interested persons, 3 minutes, and a timer will be used. All persons expecting to testify, please stand at this time, raise your right hand, and take the following oath. Do you swear the statement you're about to give is the truth? If so, answer I do. Thank you. The order of this hearing is as follows. The board's advisory team will give a short presentation describing the hearing panel recommendation. The prosecution team, Gurmile Carr, and interested persons will then be permitted to make their brief statements. Please state your name, address, affiliation, and whether you've taken the oath before testifying. If you haven't submitted a speaker card yet, now is the time to submit one to Ms. Lanfranco Rosardi. Does Regional Board Advisory Team Council have any legal issues to discuss at this time?
Not at this time.
Are there any procedural issues that the designated parties would like to raise? Seeing none, we will proceed with a advisory team presentation.
Good afternoon, Mr. Chair and members of the board. My name is Adam Lapitz, Assistant Executive Officer with the Central Valley Water Board, Rancho Cordova office, and I have taken the oath. Today I'm going to present a summary of the hearing panel recommendation for proposed administrative civil liability for Gurmile Carr of Madera County. Mr. Carr owns approximately 73 irrigated agricultural acres and grapes. A field inspection found evidence of commercial irrigation, and the alleged violation is failure to obtain regulatory coverage for discharges from their irrigated lands. In summary, the discharger failed to enroll. The East San Joaquin Water Quality Coalition waste discharge requirements were adopted in December of 2012. Because the discharger had not enrolled, a first 13260 directive requiring them to obtain coverage for their discharges was sent in January 2015, but was returned unclaimed to the board. During the panel hearing, the discharger noticed us that they were out of the country at the time and could not claim that. Second 13260 directive was sent out in June of 2016, and that was claimed. In August 8th of 2016, a ACL complaint was sent, and in August 11th, 2016, the discharger enrolled in the program. The maximum liability amount for this is $34,000. That's due to a number of violation of 34 days from the sending date of the 13260 directive. So within 34 days, the discharger enrolled in the program. The proposed liability was $32,175 initially. This was reduced by the prosecution team close to the panel hearing date to a lower number due to the quick response of Mr. Carr in enrolling in the program. There was also some and I'm sorry, I'm making a mistake. Patrick is telling me it's Miss Cower, and I apologize. No disrespect intended. What I wanted to say was there was a personal tragedy in the family, and that was also brought forward at the testimony, a death in the family. Based on the information in the record and the testimony, the hearing panel recommended $19,965. The November hearing panel voted 2 members yes, 1 member no, for the full board to approve administrative liability in the amount of $19,965. That ends my presentation.
So Adam, if it wasn't just a death in the family, it was a death of the primary operator of the farm?
LaFarther.
That's correct.
And he was, as I recall, he was the one that was receiving the information from the board, working with the coalition. And
That's my understanding. And when he
Yes.
was out of the country, he couldn't claim that first 13260 directive.
that's right. So, any questions? I know we're ready for presentations. Any questions of the advisory team before we go on? Seeing none, let's take a statement from the prosecution team.
Dr. Longley and members of the board, I'm Andrew Altvogt, Assistant Executive Officer in the Rancho Cordova office, and I have taken the oath. As Mr. Lappitz indicated, there was testimony that the panel received that we as prosecution team believed mitigated the penalty that we had originally proposed, and we still believe that that penalty may be appropriate in this case. And I will just point out the way that we arrived then at that lower penalty was by reducing the number of days from 30, which was the initial complaint, to 7, and then also reducing the culpability from a 1.3 to a 1.1, and the cleanup and cooperation from a 1.5 to a 1.1, resulting in that $4,000 penalty. So we believe there could be room for the board, if it so chooses, to reduce the penalty further.
And the exact amount, if I'm not mistaken, was $4,659.
That's correct, Dr. Longley.
Thank you. Very good. Any questions? Seeing none, Mr. Kaur, and I have to apologize if I'm mispronouncing your name also.
I believe it's Gurjit
Yeah,
Minjal.
I'm actually the son.
Yeah.
I'll be representing my mom. Her name is Camel Kaur.
Kaur?
Yes.
Okay, thank you.
Okay, and I have taken the oath. So, like I said, my father passed away in 2015. I just got involved with the ranch in 2016, and the first directive we got was in June. And there was this paragraph on there that said, join the NOI, pay the $200, and they had a website link. And I did that, and I thought I joined and I believed I joined the thing, but I didn't know there was another application I needed to fill out. Then like 20 days later, I got a notice from the saying, okay, I didn't join the coalition. Then I called the water board and they said, I thought I joined. They said, no, you have to fill this out. And I joined that same day that I called the water board, and I paid my back due fines, and I was like, okay. So I tried, it was just a minor error on my part by misreading this little paragraph, which I thought I joined the coalition, but I didn't. And the day I found out I didn't join, I joined that same day. And so I believe I made a minor error, but not a $20,000 error.
And a question I have for you, though, was your dad handling all of the dealings with the coalition and with the water board?
Yes, he was involved with the ranch, but he was diagnosed with leukemia in 2013, so he was dealing with that. Then the first directives you guys sent was in January of 2015, which time he was in India, and he came back in February of 2015 on February 11th, and he passed away on February 13th. So he came on the 11th, he was admitted to the hospital on the 12th, and he passed away on the 13th. And we never heard anything after that, and I got this in June of 2016, and I thought I did what I was supposed to do, but I guess I didn't.
So you're reacting at the last moment, or past the last moment, actually. You were reacting after you should have, sometime after you should have joined.
Well, this letter I got in June of 2016, it said I have 15 days to join. So it was not after, this letter actually
Okay.
said I have 15 days to join. And
Okay.
after I joined the NOI and I paid the $200, I didn't get any NOV notice, or I didn't get any pre-ACL letter stating, hey, you're still, I just got a fine. And I was like, okay, and I called the water board and I said, okay, why is this? They say, oh, you still have to complete the application. Then I completed the application, paid my back dues. Then I came here, met the team, and they understood my situation too. That's why they reduced it to $4,600. And I went to Fresno hoping to reduce it to $15 because I was like, okay, it's a pretty minor mistake. And pretty much, yeah, I guess you just turned.
Well, in essence, it goes further than that, because by joining late, you didn't submit certain reports that had to be submitted. And in your particular case, so your father really was not in a position to respond to that. In fact, he was in India, he was suffering from leukemia, and he had a lot of other things on his mind, like living, as an example. And so your case, I have sympathy for the situation you were in. And I think the board, we have to have a discussion on that. Is there anyone else who has questions or comments?
And just for the record, all the information that was related here today is already in the administrative record, so we weren't augmenting anything that's out
Right.
there.
We've asked those questions before. Thank you for your testimony. So I'll close the hearing. Are there any interested persons wishing to testify? Seeing none, I'll close the hearing. And discussion will be limited to board members and members of the advisory team. You know, we came forward, and I know that I voted for this amount, $19,965. I don't believe, I know that John didn't vote for this, but John, that was a hard vote that day, and I'm not sure about how I feel today. We have yet another alternative to us. This is an issue, I think, that would recognize that there was an individual there for most of the time who was not able to make competent decisions. And there is one of the alternatives is not to act on it.
Dr. Longley, if I could, I agree with your comment. The other thing is that's key to what I hear is he did respond when he received the first notice. He filed the NOI with us and filed the fee with us, but he failed to go online and do the coalition. And we are working with the coalitions right now to improve our letters so they're more understandable. So this gentleman thought he had done what we asked him to do,
Right,
unlike others who
but
just didn't do
his
anything.
father was supposedly getting those letters before, but was not able to.
I understand, but if he
Right.
had sent in the NOI, and I'm trying to say that I'm agreeing with you that you
I
should
understand, I
reconsider this
understand.
seriously, reconsider this one.
Oh, sorry. So, as the document shows, I did not agree with the higher number, and I was fine with the $4,000 number. But certainly, if looking at it from the perspective that he did what he did something right when he found out he was supposed to do something, it just wasn't bureaucratically correct. That to me, that's not an undermining as much of the program as someone who just didn't do anything. So, I could certainly, I'm certainly not in favor of the $19,000 number. The question is, do we stick with the prosecution's number, where they support still the $46.95, or do we go lower? And I'm happy to listen.
Well, the other alternative that I'm referring to, could you state that alternative, Patrick?
Yeah, I mean, at this point, with what Dr. Longley mentioned, I think there's serious consideration, at least what I'm hearing, for three options. One, adopt the hearing panel recommendation, which is the $19,965. Adopt the proposal of the prosecution team which is $4,659, or, as the board is absolutely allowed to do, terminate the proceeding at this stage and say, frankly, in this case, there are enough mitigating circumstances that the board can exercise its prosecutorial discretion not to issue an ACL here. I do think, just for the record, that this ACL had a number of days of violation that was 34. I believe then the next lowest is about 160, and after that it goes up into into the thousands. So this was an actor who did step into his father's shoes, who was running the farm for his mother, and actually did everything that he could to sign up in an appropriate amount of time. I will say, for the record, the board has not seen any failure to enrolls, at least in my recollection, with this short of a period of time of 34 days.
And it turns out that we'll have at least one more where there are issues of similar nature that we need to discuss. You know, how do we handle these becomes very important. We struggled with that in November. I think we need to continue that discussion. Quite frankly, at this point, I would certainly go along with the decision to the one alternative that Patrick mentioned is that the board not go along with the ACL.
And what I was going to say is that, you know, in the kind of law that I practice, there's adherence, and then there's equity, and equity means fairness. And, you know, I think there are times when people do try to take advantage of a system and get caught and, you know, plead for forgiveness, and that's one thing, but which can lead to undermining of the program. But as Board Member Constantino stated, this is, I think, shows a good faith effort to comply, did in fact comply. I think there's extraordinary circumstances in what the family is going through. I also think that one of the reasons that board members are put on here, instead of it having just sort of an automatic thumbs up, thumbs down, is so that we can use our discretion and our humanity and those kinds of considerations. So I would move that we exercise our prosecutorial discretion and decline to prosecute in this case.
Do I have a second?
I mean, he offered a $15 fine, and I'd be happy with a $500 fine, but I think what Carmen said is spot on, and I will second her motion.
Carmen's moved. Bob seconded. Call the roll, please.
Ms. Ramirez? Yes. Ms. Brar? Yes. Mr. Costantino?
Aye.
Mr. Schneider? Dr. Markham?
No.
Ms. Cordara?
I'll say no.
Dr. Longley?
Aye.
Motion carries.
Motion carries. Mr. Carr, do you understand what just happened?
That was a very rare event for me.
Very rare. We don't expect to see you back here again. So, with that, we'll go to item 13. This is the time and place for a public hearing to consider administrative civil liability order for William and Maria Eggleston of Merced County. The designated parties for this proceedings are as follows: the board's prosecution team and William and Maria Eggleston. All other parties are considered interested persons. In November 2016, a hearing panel of the board considered an ACL complaint issued by the board's prosecution team. After receiving evidence and testimony, the hearing panel adopted a recommendation that the board issue an ACL order at a subsequent meeting. The board will now consider the hearing panel's recommendation. Though the board will not be accepting new evidence, the board will allow designated parties and interested persons to make brief policy statements. These policy statements may not be used to introduce new evidence. The following time limits will apply to the policy statement presentations. The board prosecution team, 3 minutes. William and Maria Eggleston, 3 minutes. All interested persons, 3 minutes. And a timer will be used. All persons expecting to testify, please stand at this time. Raise your right hand and take the following oath. Do you swear that statement you're about to give is the truth? If so, answer, I do. Thank you. The order of the board's hearing is as follows. The board's advisory team will give a short presentation describing the hearing panel recommendation. Second, the prosecution team, William and Maria Eggleston, and interested persons will then be permitted to make their brief statements. Please state your name, address, affiliation, and whether you've taken the oath before testifying. If you haven't submitted a speaker card yet, now is the time to submit one to Ms. LaFranca Rosardi. Does Regional Board Advisory Team Council have any legal issues to discuss at this time?
Not at this time.
Are there any procedural issues that the designated parties would like to raise? Hearing or seeing none, we'll proceed with the advisory team presentation. We'll begin, then we'll go forth with a statement by the prosecution team. Go ahead, Adam.
Good afternoon, Mr. Chair and members of the board. My name's Adam Lapitz, Assistant Executive Officer here in the Rancho Cordova office. I'm going to present a hearing panel recommendation for proposed administrative civil liability for William and Maria Eggleston of Merced County. And I have taken the oath. The Egglestons own approximately 19.5 irrigated agricultural acres in almonds. A field inspection found evidence of commercial irrigation, and the alleged violation is failure to obtain regulatory coverage for the discharges from their irrigated agricultural lands. In summary, the dischargers failed to enroll. The East San Joaquin Water Quality Coalition order was adopted in December of 2012. They previously had enrolled in 2013, but had lost their membership due to failure to pay dues. Because they were not enrolled, a 13260 directive requiring them to obtain regulatory coverage was sent to them in November of 2014. They enrolled in March of 2016, and an ACL complaint was issued in August of 2016. The maximum liability amount for the ACL complaint was $491,000. This was a total number of days of violation of 491 from the issuance of the 13260 directive. Under the enforcement policy, the days were collapsed to 22 days. This resulted in a proposed liability amount of $22,022. After deliberation and consideration of the record and testimony, the hearing panel recommended an amount of $23,716. During the panel, the recommendation was voted on by all three board members of yes to recommend that the board adopt administrative civil liability in the amount of $23,716. This concludes my presentation.
Thank you. I'll take testimony from the prosecution team.
Dr. Longley and members of the board, Andrew Altavogt, Assistant Executive Officer in the Rancho Cordova office, and I have taken the oath. I just wanted to say that the prosecution team agrees with the panel recommendation in this case.
Thank you.
Question, Andrew? I voted yes, and I don't actually remember all the details. So, is there the fact that it's only 19 acres, does that affect your view of this proposal at all?
It was something we took into account, the size of the operation. Right. There was also, we had difficulty getting responses from them. We were in contact with the Egglestons, but we didn't get much communication back, and so that was really a big part of it. We felt like that.
And they were in, and because they were in once and then went out, there's no way to say you didn't know what was going on or something was going on. That's right.
That's
okay.
correct.
I remember that. Okay, thank you.
Very good. Any further questions or comments? Thank you. We're now prepared to take a statement by William and Maria Eggleston. Seeing no one coming forward, are there any interested persons? Seeing no one, we'll close the hearing and limit discussion to the board members and members of the advisory team. What is your pleasure? Mr. Markham?
Small farm.
True?
Was there any, I'm sorry. Did the family mention anything as far as ability to pay? Nothing?
I don't recall that as being an argument. There was this whole issue of lack of communication, not responding.
Were they
Just-
at the hearing? I'm going through.
I was just about to say, they were a no-show at the November
Okay,
hearing.
it seems, I don't see it anywhere. I
So-
guess my concern would just be that what Dr. Markham said, it's a small farm.
But if they don't show up to defend themselves, it's
Yeah.
pretty hard to make the argument for them, in my opinion.
Agreed.
And it also, I mean, this is, I think, the kind of thing that could undermine the program. where
Exactly. We have a
there's
lot of
just
small
silence.
farms out there. The majority of the farms are small farms, under 60 acres.
Yeah, and, you know, everybody gets, you know, under the same regulation. People have the opportunity to enroll. If they miss it and there's a reason that we should consider extenuating circumstances, then we will. But if there's no participation, then that communicates to me non-interest, non-participation. I'm not at all inclined to consider anything lower than what's proposed and what was recommended.
And most importantly, a lack of cooperation to be in compliance.
Yep, exactly.
And just to make it clear for the record, the prosecution team did communicate with the Egglestons. They had a meeting, and there's evidence in the record that they did receive the administrative civil liability complaint.
So I can't, they're not here. We can't explore their thinking on this matter. Do I have a motion?
I so move to entertain a motion that was before from the hearing panel of November 3rd, $23,716.
Do we have a second?
I'll second this one.
It's been moved and seconded. Any further discussion? Call the roll.
Ms. Brower,
Yes.
Ms. Ramirez, Mr. Costantino,
Aye.
Mr. Schneider, Dr. Markham,
Aye.
Ms. Kadara,
Yes.
Dr. Longley.
Yes,
Motion carries.
thank you.
Can we have 2 minutes?
Item 14. We're
Yes,
going to go to
ma'am.
item 14.
Dr. Longley,
Yes.
I think the advisory team would like a little bit of a break, please.
1 minute.
They'll take whatever you'll give them.
We-
And then
Somebody's
they'll
been watching a lot
violate
of
your order.
Senate hearings.
Try to
and-
be back. Well, we're going into recess. Be back here by 10 after, please. We're back in session. This is the time and place for a public hearing to consider an administrative civil liability order for Brooks and Arlene Rushing of Stanislaus County. The designated parties for this proceedings are as follows: the board's prosecution team and Brooks and Arlene Rushing. All other parties are considered interested persons. In November 2016, a hearing panel of the board considered an ACL complaint issued by the board's prosecution team. After receiving evidence and testimony, the hearing panel adopted a recommendation that the board issue an ACL order at a subsequent meeting. The board will now consider the hearing panel's recommendation. Though the board will not be accepting new evidence, the board will allow designated parties and interested persons to make brief policy statements. These policy statements may not be used to introduce new evidence. The following time limits will apply to the policy statement presentations. For the prosecution team, Brooks and Arlene Rushing, and all interested persons, 3 minutes, and a timer will be used. All persons expecting to testify, please stand at this time, raise your right hand, and take the following oath. Do you swear that the statement you're about to give is the truth? If so, answer, I do. Thank you. The order of the hearing is as follows. The board advisory team will give a short presentation describing the hearing panel recommendation, followed by the prosecution team, Brooks and Arlene Russian, and interested persons. Please state your name, address, affiliation, and whether you've taken the oath before testifying. If you haven't submitted a speaker card yet, now's the time to submit one to Ms. Lantranchi Rizzardi. Does Regional Board Advisory Team Council have any legal issues to discuss at this time?
No, Dr. Longley.
Are there any procedural issues that the designated parties would like to raise? Hearing and seeing none, we will proceed with the advisory team presentation.
Good afternoon, Mr. Chair, members of the board. My name is Adam Lapitz, Assistant Executive Officer here in the Rancho Cordova office. And I have taken the oath. Today I'm going to present the hearing panel recommendation for proposed administrative civil liability against Brooke and Arlene Rushing of Stanislaus County. The Rushings own approximately 38 irrigated agricultural acres of almonds. Field inspections found evidence of commercial irrigation. The alleged violation is failure to obtain regulatory coverage for discharges from their irrigated lands. The discharger failed to enroll. The East San Joaquin Water Quality Coalition order was adopted in December 2012. Because they had not enrolled, a 13260 directive was issued in May of 2014, and a notice of violation issued in July of 2014. On August 8th, 2016, an Acl complaint was issued. The discharger enrolled on September 23rd, 2016. The maximum liability amount for this is $802,000 for a total number of days of violation of 802 from the issuance of the 13260 order. The days were compressed to 32 days for an initial proposed liability amount of $34,320. In considering the evidence and the record and testimony at the hearing, the panel recommended reducing this to $12,500. And the reason for this was the concerns regarding the health of Mr. Rushing and questions whether he had the capacity to carry out the requirements of the program and the ability to do so. He's suffering some pretty severe health issues.
And in fact, he was suffering from dementia, among other things. This is in the record. His wife testified that she had to hide the keys to the tractors from him. He was making decisions. He wasn't making decisions. He was simply taking things, sometimes scribbling his name. I have to admit that I have a bias here. My father went through the same thing and screwed up finances for his and my mom's small farm. I've seen it, and it's severe. You don't know what's going on for a long time until you finally realize that you're in a pickle, and it's the family member that finally typically picks it up.
So the panel considered the evidence in November and voted. All three board members present voted yes to assessing administrative civil liability in the amount of $12,500. This concludes my presentation. I can answer any questions you have.
And if I could, just to correct one thing, I believe on the slide it says that there's 38 acres, 38 agricultural acres. There's actually, it's 30 acres that were owned, but only 30 of them were in irrigated acreage. And the record, just so that everybody is clear, Brooks Rushing was testified, had a stroke in 2008 and was in September recently put in a care facility.
Thank you. So, what is your pleasure?
At this point, it would be the prosecution team.
Oh, hey, we haven't gotten there yet. I'm trying to speed things up here, you know. Maybe I'm, okay. Take a statement by the prosecution team.
Dr. Longley and members of the board, I'm Andrew Altivogt, Assistant Executive Officer in the Rancho Cordova office. The first thing I wanted to note is that staff were in contact with Ms. Rushing today or in the past couple of days. She would have liked to be here, but she had a medical condition that made it so that she could not be here. And, you know, I think this was one that was difficult once we found out about what the situation was, difficult for the prosecution team, I believe, difficult for the panel. And, you know, we believe that the penalty that was proposed by the panel or even something lower could be appropriate in this case.
Thank you, and I might add that that's one of the things that we're seeing is there's certain groups of people that seem to be represented in front of the those folks that are not English speakers or English is not the first language, make a disproportionate number. Also elderly people. And particularly on these small farms, you see a lot of folks that try to hang on the farms, as my folks did. And they get to the point they can't operate it. So what the Rushings are not here. Are there any interested persons? Seeing none, we'll close the hearing and limit discussion to board members and members of the advisory team. I think you know what my feelings are on this one. Falls in the compassion category. When Mrs. Rushing, and I think I said that day, I think I put it in the record that day. When she was talking, I could hear my mom talking. And these people certainly were not trying to game the system, as Carmen pointed out for an earlier case. They were going through some personal tragedies, so it's whatever you come up with.
So the question I would have is the question Bob asked earlier is sort of in this manner. Does issuing this penalty protect the program, or does it not serve to advance the cause of the program? I think that would be the question I have.
And then go ahead.
There needs to be a penalty. I think we're obliged to do that, but I think it ought to be smaller than the amount stated.
There's two things I think that I would like to say as well. Is I remember this this matter pretty clearly. One of the things that we had talked about was there was no question that Mrs. Rushing was sincere in her testimony. I think that we all agreed to that. The one thing that made this case more complex than maybe some of the other cases was that she had hired a farm operator, or she was leasing the farm out to be operated by a third party, and what that third party's responsibility was. And so I think the only two people, or I don't know, maybe it's in the record, but that was one of the reasons that we arrived at this number, is that it represents sort of a fairness issue that Mrs. Rushing's, or the Rushings, had done what was in their capacity to do to comply, but also reflected that there was another party who could also have acted. So do you remember that, Dr. Longley?
And if I could,
I certainly do.
Yeah, when the board was deliberating on this item, Board Member Ramirez, sitting on the hearing panel, suggested potential administrative civil liability in the amount of $25,000 to be assessed jointly between the Rushings and the operator of the farm, or in another iteration, suspending liability as to the operator of the farm. My comment to the board at that time was that the board was constrained by the enforcement policy from doing that, and was constrained from issuing an administrative civil liability against the operator because the operator wasn't in front of the board today. What influenced the board's $12,500 was essentially taking that $25,000 suggestion and cutting it in half. And the reason that the hearing panel decided to issue an administrative civil liability at all, albeit with great reluctance, was simply because the buck stops somewhere. And in the case of the irrigated lands regulatory program, the buck stops with the landowner. The minimum liability, to get at what Board Member Markham was saying earlier, in this case would be an economic benefit from noncompliance plus 10%. which in this case was $8,135 as calculated by the economics experts. So if the board were to issue an ACL, and if the board were to issue an ACL in the minimum amount, that would be the minimum amount for the ACL. The board also could exercise its prosecutorial discretion, I believe, as Chair Longley has commented, could be an option to not assess administrative civil liability at all and essentially dismiss the proceeding here today.
Could I ask Adam a question, Dr. Longley, about the irrigated lands and the NOI? And I know the landowner is ultimately responsible, but how is the NOI structured? Is that to be done by the operator of the land?
I don't know fully the details of that. I know that the landowner is ultimately responsible, but we did, when we adopted the program, have some, the ability for a landowner or an operator to enroll, but there needed to be some communication between the two to make sure that they knew, like, so for example, a landowner knew that an operator had enrolled, and that's because, actually you'll see a case like that here today where someone may be out of state, own the land, or a conglomerate own the land, and so there needed to be that feedback loop. But ultimately, the responsibility, as Patrick said, would land back on the landowner.
Ultimately, but I think really the first line we go after is operator of the land, because they're the ones who have to implement the best practices that we're requiring. So I don't know. I think the operator does have some responsibility here, and I don't see anything where we went after the operator at all, although the landowner, and we're here to make sure we have compliance with the order. And I don't know Miss Rushing, but I don't know if she understands that now her operator has to be compliant with everything in the order. I'm kind of concerned with the ultimate goal of this action is to get compliance. I'm not sure we're getting it the best way here in this case.
And I would suggest, in this case, this order is an enforcement order of a directive that was issued to the owner, saying pretty specifically, landowners must apply to the Central Valley Water Board to join a coalition. It is entirely possible, in the vein of what Pamela is saying, that this board could broaden the scope of those directives.
In fact, and I have to go to the personal example again because my father already passed away, but my mom got a notice that she had to join a coalition. And she was leasing a small amount of land it's for strawberries. And she called me and complained about the letter she got, and I told her to look at the signatures at the bottom. She read Pamela Creedon's name, and then I said, well, what's the other name down there? And then she screamed, Carl Longley. But the point of the matter is, moving past that, I made sure that it was the leasee, not she who signed off. She had to sign somewhere, but the leasee was the one that paid this. And this was with the Tule River Coalition. And so I don't know if all coalitions are the same or not, but there is, at least in that one, and I would suspect in others, the ability for the individual who's actually doing the farming and who enjoys the profits or losses based on their farm operation to pay the fees and to be responsible for the implementation. Now, you're right. You want the owner to have the responsibility to make sure that that individual is doing that. But there is a mechanism. And to go one step further, I'm not sure that everybody reads that thing that closely nor has the ability to fully understand the implication of that language. So I think Pamela's right. I think we need to find ways of communicating that for these folks who are leasing land, and that they have that they can ensure that the leasee is the one that signs and has ultimate responsibility if they screw up. But if the owner can show due diligence in ensuring that they are doing what they're supposed to be doing, albeit a statement in the lease itself that they have that responsibility, and that they will pay, but any good attorney can tell you how to write that lease. And maybe we need to stress that.
Absolutely, and I believe that issue came up at hearings before. And again, I believe this discussion certainly falls within the scope of the evidence that's been received already because the general order itself is a part of the evidence. And I think that when the general order was adopted and the information sheet attached with the general order did emphasize that legal responsibility generally resides with the landowner for these types of things. Frankly, and the board went that route to avoid absentee landlords quit claiming any responsibility for the parcels that they own and generally make a profit off of, at least in the good years. But it's duly noted that the board can emphasize in these notices that are sent out to growers that it is entirely possible to divvy up the responsibility via a contractual relationship or otherwise with tenants who operate your land.
And then if the owner is sued, the amount is simply passed on to the leasing.
That's entirely a possibility.
So what I was going to say is that even though I did remember feeling sympathetic and believing the testimony of Ms. Rushing, right now, as I sit here, I'm not necessarily inclined to change the dollar amount because I don't think that there's going to be a big, rash of things happening, but I would not like to see that devious persons could think that if they lease from property from people who are elderly or otherwise have limited capacity, that they could sort of skate by these regulations. So again, I don't think it's a big possibility people are going to rush out and try to interview landowners that don't have capacity and sign up with them. But I think that there is something that is owed, and hopefully the appropriate party is the one who handles that. But at this time, I would still support a penalty. And what was the minimum plus 10%, Patrick?
8,000 something.
8135?
Exactly. 8,135.
Okay, well, I'll end my comments there and see if anybody on the dais is willing to make a motion.
Well, why don't you float your motion, Carmen? We can always vote it down.
Thanks. Even though I said that I stand by my 12.5, I'm going to make a motion that that we accept the hearing panel's recommendation and issue the ACL in an amount of the minimum economic benefit plus 10% for the dollar amount of $8,135.
I'll second it.
And I'll just say that I appreciate the debate. That answered my original question.
Pardon?
I appreciate the debate, and that answered my original question as to whether there was value in assessing a penalty on this one.
I'm sorry, I don't understand. You think that answered your question, or do you want more?
No, it answered my question.
Very good, thank you. Any further discussion on this item? I have a motion and a second. Hearing none?
And just to clarify, because this ACL order is already structured to bring the penalty amount down based on other factors as justice may require, we don't have to go in and tinker with the findings of the order as much as if we were to change one of the factors. So in this case, it would simply be a substitution of the $12,500 for the minimum economic benefit plus 10%, which is the $8,135.
And the panel had already lowered it substantially, so this is in line with what the panel was doing.
It is consistent. All you have to do is switch out those two numbers.
And I think that justice requires this.
Thank you. Call the roll, please. You're going to be calling the roll in the middle of the night.
Dr. Markham,
Aye.
Mr. Schneider? Ms. Brower?
Aye.
Ms. Ramirez?
Yes.
Mr. Costantino?
Yes.
Ms. Cadara?
Yes.
Dr. Longley?
Yes,
Motion carries.
thank you. I think we did a good job on that one, as I think we've been doing pretty much all along. We'll move to the next item, item 16 on the agenda. Did I miss 15? Whoops, where is 15? Sure did. We'll move to item 15. This is the time and place for a public hearing to consider an administrative civil liability order for Emma Bounds of Madera County. Designated parties to this proceeding are as follows: the board's prosecution team and Emma Bounds. All other parties are considered interested persons. In November 2016, a hearing panel of the board considered an ACL complaint issued by the board's prosecution team. After receiving evidence and statement, the hearing panel adopted a recommendation that the board issue an ACL order at a subsequent meeting. The board will now consider the hearing panel's recommendation. Though the board will not be accepting new evidence, the board will allow designated parties and interested persons to make brief policy statements. These policy statements may not be used to introduce new evidence. The following time limits will apply to the policy statement presentations. The board prosecution team, Emma Bounds, and all interested persons will have a total of 3 minutes, and a timer will be used. All persons expecting to testify, please stand at this time, raise your right hand, and take the following oath. Do you swear the statement you're about to give is the truth? If so, answer I do. Thank you. The order of this hearing is as follows. The board's advisory team will give a short presentation describing the hearing panel recommendation. Prosecution team, Emma Bounds, and interested persons will then be permitted to make their brief statements. Please state your name, address, affiliation, and whether you've taken the oath before testifying. If you haven't submitted a speaker card yet, now is the time to submit one to Ms. Lanfranchi Rosardi. Does Regional Board Advisory Team Council have any legal issues to discuss at this time?
Not at this time.
Are there any procedural issues that the designated parties would like to raise? Hearing none, we will proceed with the advisory team presentation.
Good afternoon, Dr. Longley and members of the board. My name is Adam Lapitz, Assistant Executive Officer here in the Rancho Cordova office, and I've taken the oath. I'm going to present hearing panel recommendation for proposed administrative civil liability for Emma Bounds of Madera County. Ms. Bounds owns approximately 69 irrigated agricultural acres in Almonds. She enrolled in the East San Joaquin Water Quality Coalition in March 2006. The East San Joaquin Water Quality Coalition order, waste discharge requirements, requires all members to complete farm evaluations. For farms located in this area, high vulnerability area, farm evaluations are due annually. In May of 2014, March of 2015, and March of 2016. The alleged violation is failure to submit farm evaluations for 2013, 2014, and 2015. In February 2016, a notice of violation for failure to submit the farm evaluations was sent. In May of 2016, a final notice was sent regarding the 2015 farm evaluation. There were also a number of coalition outreach attempts to ensure these farm evaluations were turned in. Farm evaluations were submitted on August 26, 2016, after the ACL complaint was issued in August 8th of 2016. The maximum liability amount for this violation was $1,516,000. That's due to a total amount of violation days of 1,516. And I'll talk about this a little later, but this is similar to ACL you heard in December for Silvera ACL, where the violations stacked up, where you have more than one report due, and they stacked up together, and that's why we have so many days here of violation. This is, of today's items, it's I believe, the most days of violation. Under the enforcement policy, these violations days were compressed to 70, and the proposed liability amount was $70,980. After hearing testimony and considering the record, the hearing panel voted to request that the board approve or recommend that the board approve an administrative civil liability order for $70,980. All three panel members voted yes. Like I spoke of earlier, this is one, there was after this panel hearing in December, so the panel hearing was in November. The board considered a Silvera ACL at that board meeting and had a little bit of a different approach for a very almost in exactly the same type of case as far as not reported farm evaluations. So I have a few slides in addition beyond this that I'd like to give, but it's your pleasure.
Certainly, because I'm glad you brought up the Silvera case, because in a sense, the full board has already considered this case and has made a ruling which is considerably different from what the panel did. I was a member of that panel, and I've changed my mind considerably based upon the Silvera case.
Okay. Okay, so we termed that was stacking violations in December. And in this case, what we have, as I mentioned earlier, was the failure to submit 3 farm evaluations, 2013, 14, and 15. When the first one in 2013 was due and was not sent to us, there was a violation for each day after the date of requirement. The issue becomes an issue in 2014 on the next farm evaluation, then you get 2 days. And then on the third one, you get 3 days. And what can happen very quickly is you could actually wind up with enforcement penalties because of the way the enforcement policy and the water code are structured, where a non-enroller or non-filer would have a smaller enforcement liability than someone who was in the program and didn't furnish these reports, these farm evaluation reports. And here's a graphical representation. The dates the dates, I didn't have enough time to make sure all the dates were just right in this, but this is a graphical representation of what we have here. And maybe just simply put, on top we have the non-enroller, and each yellow block represents a day of violation, for example. And then a non-reporter on the bottom and this would be for the farm evaluation type of reports. And you can see on the bottom there, and I can maybe point at it with my mouse here. You can see in the beginning it starts to stack up rather quickly after the second and the third, where you're getting 3 violations per day. And what happens is you wind up with a higher liability than if they didn't enroll at all. The board has discretion in this case, just like they did in the Silvera case, to count the farm evaluation reports as in this special case, to not count them distinctly, but to count them as 1 violation per day, even though there wasn't there was 3 reports that were due. And what that would do is, in this graphically represents this case where a non-enroller on the top would be getting a 1 day of violation for a day of not enrolling in the program, but on the bottom, the non-reporter, instead of getting up to 3 violations for 1 day, you would align this and you could correct that or rectify that issue of if they never signed up at all, they would have a smaller penalty. So this just numerically shows what could happen. Total violations, the top, just focus on the yellow text here, 1,516 days that was compressed to 70. If you don't stack them, you go down below here, 830 days, which can be compressed to 34 days. That substantially reduces the number of days. And numerically, I believe I have one more slide here. Numerically, the proposed ACL that you saw at the panel hearing was 70,980. If you do not stack the days, you could reduce this to 34,476. That concludes my presentation.
Thank you very much.
Okay, Adam, is that consistent with the Silvera? Silvera was in the 20. There was another factor.
There was another factor in the
Thank you.
Silvera. So if the board is so inclined to go in this direction, that would open the door for additional discussion for consistency with the Silvera order. But at this stage, I would suggest opening the comments from the prosecution team and from the discharger, and then deliberating on whether this is.
We'll go to
what you
the
wanna
other
do.
issue. Great. Prosecution team?
Dr. Longley and members of the board, Andrew Altavogt, Assistant Executive Officer in the Rancho Cordova office, and I have taken the oath. I just want to say that we understand and agree with the revision that was proposed in terms of the days and the stacking. I did want to touch on it was brought up the difference between some of the other factors between the Silveras in this case. I think the factor that was changed for the Silveras case was the cleanup and cooperation was reduced from 1.3 to a 1. And in this case, I believe the amount that you're seeing, the 34,000, was based on a cleanup and cooperation factor of 1.3 still. We do believe that having that cleanup and cooperation factor above 1 is appropriate because it did take getting and issuing an ACL before these reports came in. So we would recommend keeping the cleanup and cooperation above 1. Thank you.
Thank you. Is Emma Bounds here? Do you wish to testify, ma'am? She didn't take the oath. Yeah, I didn't. Do you wish to testify on behalf of Emma Bounds, sir? Yes, I have a card up there. Yes, okay. Come forward, please.
Thank you. My name's Carmen Rigeri, 30029 Road 400, Corscold, California. I'm son-in-law, have taken the oath. I drew the short straw, and so I'm here. I'm going to read a statement by Christopher Brown. He's Emma Bounds' attorney, chair of Real Estate Environmental Law Department, Dowering Airland Incorporated, 8080 North Palm, Fresno, California. And I'm just going to read it word for word. And he does refer to the Silveria case. I, Carmen Rigeri, am here on behalf of Emma Bounds with respect to this matter and the board's policy surrounding the matter. The key policy issue is fairness and striving for consistency and even handling of the parties that have alleged to have committed various water quality violations in the same nature as Ms. Bounds. In the matter of Joe Silveria, Administrative Civil Liability Order R5 2016-0085, the facts are almost identical to Mrs. Bounds' matter, except that certain factors should lead the board to be more lenient on Ms. Bounds than Mr. Silveria. In fact, good policy should dictate a less severe financial liability amount for the failure of Ms. Bounds to submit the farm evaluations. Since the facts of the Silveria case on noncompliance are almost identical to those of Ms. Bounds, good policy would dictate that you use the same mechanism for calculating any sums owed by Ms. Bounds. The three factors used by the board in the Silveria case to determine the ultimate dollar amount were culpability, cleanup, and cooperation, and history of violations. Mr. Silveria scored 1.3, 1.0, 1.0 respectively, while Ms. Bounds scored 1.3, 1.3, and 1.0 respectively. However, good policy would dictate that you only score Ms. Bounds 1.0, 1.0, and 1.0 respectively. With respect to cleanup and cooperation, Ms. Bounds' compliance and activities with respect to such items are close to identical or identical to Mr. Silveria from the information reviewed, and therefore Ms. Bounds should be no more than 1.0 as is Mr. Silveria. In regard to culpability, Ms. Bounds is less culpable than Mr. Silveria. Unlike Mr. Silveria, Ms. Bounds does not live in California, even though the notices were provided to Ms. Bounds' last known California address in the Water Board's records. Ms. Bounds has been living out of state for several years. Unfortunately, the notices were sent to Ms. Bounds, went to the current tenant on the property who did not notify Ms. Bounds until he received the notice of the last hearing. Perhaps you could say Ms. Bounds was negligent in not providing the new address, but to apply any culpability to not responding by her is unfair and unjust, especially considering that when she was active in the farm, there was really no interaction with the Water Board, and she forgot that she had even signed documentation with respect to the Water Board in this matter, partly because of the fact the matter was unclear to her at the time and her husband later died. It was not part of something that most people would think about and realize they needed to provide an alternate address to the Water Board. Thus, it is not fair to judge Ms. Bounds at a higher level of culpability than Mr. Silveria when she is elderly, no longer involved in the farm, lost her husband, and in the meantime moved out of state. Thus, using the same determination method used in Silveria, The initial liability of $20,400 multiplied by the adjustments, all at 1.0, Ms. Bounds' liability should be no more than $20,400, if anything at all. If you disagree with the good policy reasons for the reduction of Ms. Bounds' culpability and cooperation in cleanup factors, the most exposure she should have in this matter is the amount of $34,476. In any event, it is my expectation at a minimum you would agree to the reduction of at least one of the factors, whether it be cleanup and cooperation or culpability, which would make her exposure in the amount of $26,520. Again, based on what I believe to be good and consistent policy, Ms. Bounds should not be penalized with any monetary amount, as her only mistake was forgetting to provide the water board with her change of address. Thank you for your consideration.
Thank you. Any questions from members of the board? Thank you, sir. Are there any interested persons wishing to testify? Come forward, David. Have you taken the oath?
I have not.
You raise your right hand. Do you swear the statement you are about to give is the truth? If so, answer I do.
I do, even though I'm an attorney.
Thank you. You're not testifying as an attorney at this point.
I just wanted to point out, and I didn't intend to testify, but Adam told me that I always do, so I figured I'd get up and at least one of these have to do it. This does have a lot of broad implications to the Irrigated Lands Program, and I know some of the other coalition leaders, this is one of a very important issue to them in terms of large ACL fines to folks who haven't turned in forms, reports versus non-enrollment. And the preference had been there to really focus on the non-enrollment issues and then work on the non-filing of reports. Now, that's not to diminish the importance of reports. They really are an integral part of this whole program, and it's not to diminish that importance at all. But it does set up some strange dynamics in the ag community when there are still growers out there who haven't enrolled and they're sort of getting off scot-free, and you've got someone who at least is enrolled and somewhat engaged and being fined what is a large amount. So I don't know what the right amount is. I don't know what, those issues, but there's a lot of policy issues involved here that implicates sort of a lot of issues in the Irrigated Lands Program. And I just think you should be thoughtful in how that goes about. And I don't know whether you have to act today on this. I don't know what the right way to go with this is, but I know Silvera was a non-filing of reports, right? The prior one?
This is very similar to this one,
Yeah.
yes.
But I don't know that the board has had that full discussion as to what the appropriate mechanism is to deal with the non-filing and what are the appropriate levels to induce people turning in these reports and compliance and not be so onerous and not sort of turn this upside down so folks who are at least have enrolled are being treated, not being treated more onerously than those who haven't enrolled. So anyway, I don't know if I didn't do that very eloquently, but you understand my concerns, and I just wanted to let you know
We
there are
always
some big
understand you, David.
policy issues. So thank you.
Thank you very much. Any questions? Mr. Corey? Thank you, David. With that, I'll go ahead and close the hearing, confine discussion to members of the board and the members of the advisory team. As was mentioned in the letter provided by her attorney, the other amount, if you take the 1.3 factor out, is $26,520. What is your thought on that, Patrick?
Well, I think there's a couple comments. First of all, I know the letter did say that Ms. Bounds is living out of state and that the only fault was not providing her forwarding address. That kind of implies that there's no relationship between Mrs. Bounds and the person who's running the farm. Her son was running the farm. Monty Bounds was getting the mail, was signing for the mail, and the board has that in evidence. That said, the situation or the comparison between Ms. Bounds' case and the Silvera ACL order is very striking. There are almost identical cases with almost identical violations and almost identical compliance periods. Frankly, Ms. Bounds complied within just a few days of Mr. Silvera complying with the orders. So the fact situations, in my opinion, are as similar as they can possibly be between two cases that the board may hear. And so in my suggestion, given that the Silvera case, we had a lot of evidence, frankly, speaking to what Mr. Corey said about how we should not penalize non-filers or people who don't file their farm evaluations to a greater extent than the people who don't enroll in the Irrigated Lands Regulatory Program, and who the board has to chase down and get them to pay the coalition fees and their WDR fees. Sorry, I'm rambling on, but to make sure that the people who don't enroll are punished to a greater extent than the people who miss a few reports. Not to say that that's not serious, but that it's different by a magnitude from the folks who don't comply with the program entirely.
And the difference between Silvera and this was the 1.3 versus 1.0 for which category?
It was for cleanup and cooperation.
Cleanup and cooperation.
And essentially, the board's finding with the Silvera ACL was that they complied very soon after realizing the severity of their noncompliance. And I believe it was 18 days after receiving the ACL order or complaint. And Ms. Bounds, I believe, was 15 days. I may have those reversed,
Right,
but
so-
it's within a few days of each other, at least as the fact situation
And if
shows.
we would go from 1.3 to 1.0, that takes it down to 26,520.
Exactly.
What's your pleasure?
Well, in my case, I'm quite uncomfortable with talking about Silvera versus Bounds. To me, I look at Bounds alone, as a standalone thing. What I'm sympathetic to is not stacking. That's what I'm sympathetic to.
And I believe that would be entirely correct. Bear in mind that none of the decisions that this board makes are, frankly, binding upon this board. The board has the ability to change its mind and weigh evidence differently in a different case. I would strongly suggest all the board members keep Board Member Markham's comment in mind. The one policy decision that would be, frankly, a big deal to reverse is that stacking. The other factors the board should independently consider here today.
Thank you. So, any further discussion, or is someone willing to make a motion?
Yeah, I'll move to adopt 34,476.
And I guess the language with that is to adopt the findings of the panel, but with the amount. You can do it better than I.
In this
Patrick.
case, we would have to have a brief recess. We have prepared some language for the board, but there are a number of revisions to the ACL order that would be required to adopt that 34,000 number. We've got almost all of them written up as one of the options, but we would need to kind of put it together.
And how long of a recess do you need?
I imagine only 5 minutes.
We'll give you 5 minutes.
I hear what you're saying, because that's usually how I work individually, but I think consistency is a goal in a lot of cases, and only because in these two cases, and because I was at the last case too, the Silvera case, I think looking at that consistency is appropriate, and in some respects, good policy in this case.
Well, let's discuss this further before you run out and give us the written statement, because maybe we don't go with it. I heard you, Dan, talk about that you were not wanting to go with the case. However, I think Bob, in my opinion, my humble opinion, brought up a very good point, and that is consistency. People have to know what to expect, and we are, and unfortunately, we're doing this in live time, but we're attempting to try to get to a point of consistency, and I think we've come a long ways to getting there. We've certainly gotten past the non-stacking, it appears. I have heard no objection from any board member as to that practice. But I do think now when we see similar circumstances, and it's easy to see them when we have a lot of within a short period of time. I would tend to agree with Bob that we need to attempt to do the same, give the same kind of penalty for the same kind of same degree of error that made on the part of the discharger.
And I want to add to that, and with a little bit of respect to what Dan said, is that doesn't mean I would do exactly the same thing 6 months from now. I mean, if the words, I mean, these were so close in timing too, that enters to my thinking. But 6 months down the road, people should know not to be doing this because we've done this. And if they're still acting or not acting 6 months from now, I might feel differently and feel like there's more culpability. So,
And if I
it's
could,
not totally a precedent. It's just these were equal cases at equal time.
and if I could, just for in particular for the new board members, we deliberate on these factors quite a bit. But cleanup and cooperation, what it means as far as the enforcement policy is concerned, is quote, extent to which the discharger voluntarily cooperated in returning to compliance and correcting environmental damage, including any voluntary cleanup efforts undertaken. Adjustment should result in a multiplier between 0.75, that's for cooperation, to 1.5, excuse me, with the lower multiplier where there is a high degree of cleanup and cooperation and a higher multiplier where this is absent. And essentially the 1.0 in the Silvera case was due to the fact that the board recognized that they tried to come in compliance upon realizing the severity of the violation. But generally speaking, most of the ACLs for non-filers and non-enrollers have a cleanup and cooperation of about 1.3. Some have ranged upward to 1.5.
Patrick, I have a question. How many days apart was the cleanup with the Silvera case versus this case?
Let me take 1 minute. I believe it was 3 days, 3 days difference. So because they're in the same coalition and because they missed the same reporting deadlines, all of their violations were moving in lockstep. The complaints were issued right about the same time, and they both came into compliance by submitting the past due farm evaluations right about the same time. So all told, it's about 3 days worth of difference between the two parties. And considering that as initially charged, there was 1,500 days of violation, that's pretty darn close.
Okay, and we used a 1.0 with the Silvera case.
We used, yes, a 1.3, a 1.0, and a 1.0 with a cleanup of cooperation was the middle value of the 1.0, and it's being charged as a 1.3 in this case.
Okay.
My turn? Am I good? Okay. So, you know, what Bob said resonated, that 6 months from now, on a new set of facts where these two items have been in the sort of public realm, it certainly have a different sense of consistency, what that means. But because they were sort of happening concurrently, I think we have to prosecute sort of similarly. And so I would think if we take a different stance on something that's almost identical, and we've said it's almost identical, I think that's problematic. So I think I'd go with the lower number on that.
I would agree with you on that.
Who agrees? We got two down there saying they agree. I agree.
The motion dies for lack of a second, I think, Mr. Chair.
Well, let me say this about seconds. We do seconds as a courtesy, but one time when I was ornery as the devil, and I made folks vote on it. I'd made a motion and didn't get a second. You're not as ornery as I am. We're operating under, not under Rogers, but under
Sturgis.
Sturgis, that's right. And in Sturgis, the second isn't required. But As a courtesy,
Can I withdraw?
you can, you certainly can.
I withdraw.
Thank you. We operate as if we're under Roberts to a degree. So do I have a new motion?
I'll move, I don't have the number memorized,
26,520.
but I will move that value for moving forward.
So before we go any further, and will I have a second
I will
later on?
second that.
So I'll have a second, and we will go into a 5-minute recess while our advisory team puts the language together.
And because there's not too many modifications, we do have it right here, so it's just a matter of bringing it over to the computer room.
We don't need the break, am I correct?
It might be just a minute. Just
Oh,
let me unplug
okay.
this.
Give them a little bit of time.
We'll stand in place.
Yeah, no, I got your version. Oh, yeah, yeah.
So yeah, before they had already decided, so essentially I had both versions queued up, so just the 26,520 version.
Yeah.
queued up.
I think I got it.
Yes, we're going to make an administrative decision here. The last item on the agenda, item number 26, is being, not 26, 18, I'm sorry, today's item, not tomorrow's item. Today's item, the update on compressed ACL processes was being moved till tomorrow. We'll try to do it first thing in the morning.
And I think that that's a good idea because it's an important topic and we want to give it its due course.
We don't want to rush it.
We don't want to compress it.
Thanks, Wendy. Sorry.
Oh, gosh. Okay. So,
resuming the discussion in the matter of M&J Bounds, up on the screens in front of you is the ACL order as proposed to be consistent with the Silvera ACL order. And this required changing finding 28, and this changing was essentially reducing the maximum liability based on a calculation that doesn't stack the violations. So instead of accounting for 830 days, 526, and 160 days worth of violations for the 2013, 2014, and 2015 non-submittal of the farm evaluations, it's 847 days, which represents the number of days between the time that the first report became due and the date they were submitted. Coming down, that changes the maximum liability from 1.5 million to 847,000. Finding 35, that was just a typo. And the reduction, this just reflects what's calculated in attachment A. That's $26,520. And moving to attachment A, where the calculation magic happens. Multiple day violations. Pursuant to the East San Joaquin order, the discharger was required to submit farm evaluations, a violation of which started on 2 May 2014 and continued into 26 August 2016, the day the farm evaluations were submitted, resulting in 847 days of violations. Deleting the reference to multiple farm violations there. Adding a notation as to where in the enforcement policy we're actually coming up with this calculation. And reducing it under the compression factors to 34 days.
what about A here where it says okay. Culpability
And then
1.3.
moving down, culpability remains at 1.3.
Cleanup and cooperation, right?
Cleanup and cooperation drops again. And then this would be, though the discharger did not initially respond and cooperate with the Central Valley Water Board or the coalition, despite being allowed ample time in which to do so, the discharger submitted the 3 delinquent reports fairly quickly upon understanding the requirement. Cleanup is not applicable in this case, and this finding is identical to the finding that was made in the Silvera ACL order. Again, recognizing that that order is not binding on us, but that the board wishes to borrow that policy rationale. And again, the liability calculation winds up with 26,520. And everything else stays the same. One notation to the maximum, again, being reduced. And lastly, the final liability amount being reduced to $26,520.
Thank you, Patrick. With that said, do you want to restate your motion?
I would move to adopt the revised to recommend and issue an ACL order for a different amount based on the evidence that has already been presented and received.
Absolutely.
And those, do we need to include in that motion a change to the findings?
It's
sort of
the motion
implied,
is the motion is understood as the as described by council.
As described by council.
Thank you.
This item in front of us, good.
I second that motion.
And Denise has seconded. John's made the motion. Denise has seconded. Any further discussion? Call the roll.
Dr. Balcom,
Aye.
Ms. Brar,
Yes.
Ms. Ramirez, Mr. Costantino, Ms. Kadara, Dr. Longley.
Yes.
Motion carries.
Thank you very much.
Dr. Longley, at least for the record, we should note that Member Schneider had to leave for the day. and won't
Yeah,
be here for-
thank you for that. Mr. Snyder had another obligation he had to keep, and he has departed for the day. It's my understanding he'll return tomorrow. Hence, he was not voting, was not here to vote. Why are you grinning at me? We'll move on to agenda item 16. This is the time and place for a public hearing to consider administrative civil liability order. Excuse me, I'm on the wrong one. Item 17. This is the time and place for 16? Yeah, you know, they went fast. Yep. They went fast because in my record, it says somebody else. This is the time and place for a public hearing to consider administrative civil liability order for Sing Farms LLC. The designated parties for this proceedings are as follows: the board's prosecution team and Sing Farms LLC. All other parties are considered interested persons. On November 2016, a hearing panel of the board considered an ACL complaint issued by the board's prosecution team. After receiving evidence and testimony, the hearing panel adopted a recommendation that the board issue an ACL order at a subsequent meeting. The board will now consider the hearing panel's recommendation. Though the board will not be accepting new evidence, the board will allow designated parties and interested persons to make brief policy statements. These policy statements may not be used to introduce new evidence. The following time limits will apply to the policy statement presentations. 3 minutes each will be allowed for the board prosecution team, Sing Farms LLC, and all interested persons, and a timer will be used. All persons expecting to testify, please stand at this time, raise your right hand, and take the following oath. Do you swear the testimony you're about to give is the truth? If so, answer I do. Thank you. The order of this hearing is as follows. After the board's advisory team gives a short presentation describing the hearing panel recommendation, the prosecution team, Sing Farms, and interested persons will then be permitted to make their brief statements. Please state your name, address, affiliation, and whether you've taken the oath before testifying. If you haven't submitted a speaker card yet, now is the time to submit one to Ms. Lahanchi Rosardi. Does the Regional Board Advisory Team Council have any legal issues to discuss at this time?
And not at this time.
Thank you. Are there any procedural issues that the designated parties would like to raise? Seeing or hearing none, we'll begin with the presentation by the advisory team.
Good afternoon, Chair Longley and members of the board. My name's Adam Lapitz, Assistant Executive Officer here in the Rancho Cordova office, and I have taken the oath. I'm going to present a summary of the hearing panel recommendations for proposed administrative civil liability for Sing Farms of Madera County. Sing Farms owns approximately 593 irrigated agricultural acres of almonds, grapes, walnuts, pistachios, and prunes. The East San Joaquin Order was adopted in December of 2012. Sing Farms enrolled in the East San Joaquin Water Coalition in May of 2014. The East San Joaquin Order requires all members to complete farm evaluations. For Sing Farms, he's in a high vulnerability area. Farm evaluations are due annually. Since Sing Farms enrolled in the coalition at a later date, Sing Farms the violations charged here are only for 2 farm evaluations, for March 2015 and March 2016. In summary, the discharger failed to submit farm evaluations for 2014 and 2015. In February 2016, a notice of violation for failure to submit the 2014 farm evaluation was sent. In May of 2016, a final notice regarding the 2015 farm evaluation was sent. This is also in addition to multiple coalition outreach attempts. An ACL complaint was issued to Sing Farms on August 8, 2016. The farm evaluations were submitted in August 16th, 2016, and September 26th, 2016. The maximum liability amount for these violations is $686,000. This is due to a total days of violation of 686. This is another one, and I can talk about in a little bit, where the violations were stacked because there was more than one report. Under the enforcement policy, the days were compressed to 50 days with a proposed liability amount of $59,150 and a final hearing panel recommendation amount after considering evidence and testimony was $46,475. So the November hearing panel recommended assessing $46,475 liability to Sing Farms. All three board members present voted yes. So this concludes this portion of the presentation. This is another one where there was a stacking. I can give a few more slides on this if you like. Otherwise, I can skip to the end and show you what the difference in amounts would be.
Please do.
Okay. So just similar to a presentation I gave before, these violations were stacked. If you do not stack the violations, you can essentially end up, and I'll just go over these numbers here. In yellow, the figures in yellow, prior was 686 days was the total amount. 526 days would be the amount if you did not stack the violations, which could be reduced to 30 days, not 20, I'm sorry, 30 days compressed. And here's the difference in amount. So proposed ACL of 27,885, or reduced to 27,885. So that concludes my presentation. If you have any questions for me.
So Adam, can I ask you, I think the NOI was supposed to have been submitted by May of 2013.
That's, I don't have my spreadsheet in front of me right here.
So they missed the deadline for NOI submittal, and they missed the deadline for the 2014 report, because that was due in March. So this is a discharger who's not real consistent with the other two, that late NOI missed the first report but couldn't be charged with it because they weren't under the order at the time. So he wasn't as delinquent as others, but he was able to benefit from not having filed the NOI timely.
And this is a large farm. I think we have to remember that. Once again, and I think I choose to talk about the factor here. We used the factor of 0.55 in this calculation originally. This is a large farm. If we went to 0.7, that number then would be, I have the calculation here someplace.
It'd be $35,490.
$35,490.
I'm sorry, so that's if we don't stack, then change the
0.7
0.7.
for a large
That's
farm.
correct. And this was the one where the prosecution team initially said, because this is such a large farm, let's use a multiplier of 0.7, which is at the high end of the range indicated by Table 3. The board moved it back down to 0.55 just for consistency with the other items that it had heard that day. The other items that it had heard that day were all smaller farms, however. So it was really, the prosecution team will certainly be invited to comment, but that's one thing that they tried to charge a 0.7 for.
And even if we put in the 0.7, that's less than the amount the panel recommended.
That is correct.
So, any questions of the advisory team? With that, we'll take testimony from the prosecution team.
Dr. Longley and members of the board, Andrew Altavogt, Assistant Executive Officer in the Rancho Cordova office, and I have taken the oath. Again, with the prior case, we agree and understand that with the change in the stacking, although I should mention, and I don't have our calculations right here, we came up with a slightly different number. Instead of the 526, we actually came up with 465. And I apologize, I don't have the calculations in front of me. I'm not quite sure what the discrepancy, but I just wanted to make sure the the board knew that, and we could, if the board so chose, we could go back and try to figure that
you
out.
give-
But
What was your number of compressed days?
the number of compressed days then became, if you did the full compression, which is what Mr. Lapitz did here. If you did the full compression on 465 days, then you would get to 21 would be fully compressed. So it's similar, but lower.
Interesting.
Yeah, so I apologize. I don't know why the discrepancy, but I just wanted to note that. And again, we could, if you chose, we could take a quick recess and figure out at least how we got to our number.
I think if you would like, we could take a quick look at the counting really quick.
Can you do it in 5 minutes?
I can do it in 5 minutes.
Yeah, absolutely.
Let's do it in 5 minutes. We'll come back in session in 5 minutes. So we're back in session. Did we resolve the difference?
Yes, we did. The advisory team had the correct number. We made a mistake in our calculation. I apologize, Dr. Longley.
We got a hotshot advisory team here.
Absolutely.
We just want to get it right, that's all.
That's
I
correct.
made some miscalculations too, and they were quick to point it out.
So the only other thing that I would say is just sort of reflecting on some of the earlier board discussion on the potential for harm factor and how that was calculated. Again, we originally, as Mr. Palupa pointed out, chose the 0.7 based on the size of the operation, and so we would, I think either one would be okay with that. I think there are reasons you could justify either one. The other thing is on the cleanup and cooperation. Again, Mr. Singh testified to some, I guess, personal tragedy among his office staff, which led to some of the problems that he had. And again, I think he on the one hand he had a large operation, and so I think he had a little more responsibility in some way. On the other hand, there were some mitigating factors there. But I would still suggest keeping the cleanup and cooperation above a 1 in this case. Thank you.
Thank you. So are there any questions, comments? If not, we'll take the comments from Mr. Singh.
Thanks for sticking it out.
And I think it's evening already. I do not have a whole lot to say except that I really seek compassion. I had mentioned to part of the members of the board at the previous meeting that my office manager passed away, and I don't have basic office management skills. And please do not look at the size of the farm, because I did start very small. In fact, I was a truck driver for a very, very long time, and I got into farming in '98, just bought a small farm and slowly grew into it. And another thing I wanted to mention once again is that I'm a very responsible farmer. Majority of my farming operation is organic. We buy farms and do convert them to organic. There is really not any pollution that comes out of our farms, but I still got to follow the law. Unfortunately, with my office manager passing away, I could not follow the rules and the laws properly. As promised, it's been taken care of from here on. My daughter has joined me in the office, and she's the one who's taking care of everything from now on.
Mr. Singh, I must say that you're an organic farmer. I commend you for that. But we find that with all farming operations, organic or otherwise, that there can be and typically is nutrients moving past the root zone in the operation. It's just the nature of things, and how you control that is very important. And as we go down the road in the irrigated lands program, best management practices to do that are an important part of the total package. We'll be evaluating those kinds of things. These reports are very important, and I think personally think the size of your farm is important. Simply because of a greater risk to groundwater, the larger any piece of land that is being farmed presents. So, it's something that I think we have to accept as we move forward in this program. But thank you for. Are there any other comments or questions by members of the panel of the board?
Is it appropriate for me to ask a question?
You can ask a question.
Mr. Singh, I understand it was your office manager, but it was important to the board. There's much more to this than just an administrative process. So far, it's been pretty administrative because it's just getting into the program. But do you understand that this isn't just someone filing some pieces of paper? It is requiring that you, as the operator, to do some things on the property as well. I want to make sure that that all of our dischargers who are coming to the board understand there is a responsibility on each of them to make sure they do the things that's required by the order. It's not just an administrative process.
I understand that.
Okay.
Unfortunately, I did not get proper education, and I really feel bad about that. I wouldn't have been in this situation if I did
Mr.
have
Singh,
that.
it's not just all education, it's common sense. And I recognize the office manager had a role to play in this, but you have a responsibility also. No, I think doing what you're doing, you're probably a pretty smart man. So, there's a lot of places to learn besides in the classroom. And I think you'd have to agree with me on that.
Yes.
The point of the matter is we have to make sure that we can protect groundwater and also keep farmers in business. And, we're proceeding accordingly. Are there any other comments? Thank you very much.
Thanks.
Are there any interested parties? Seeing none, we will close the hearing and confine discussion to the board members and the advisory team. So what we have here, what we're recommending is, quite frankly, something other than what the panel adopted.
And if I could suggest that there's, at least in my view, 3 decision points that the board has to make. One, whether stacking violations is appropriate or not, and I am hearing from the board that consistent with the prior orders, stacking is not appropriate in this case, which would be a deviation from the recommendation of the hearing panel. 2, whether the 0.55 multiplier as suggested by the hearing panel is appropriate, or whether a 0.7 multiplier as initially proposed by the by the prosecution team is appropriate. And lastly, whether the culpability and cleanup and cooperation should remain at 1.3 for both, or whether they should be modified in some way.
Thank you. So, with that said, the amount that has been that we could use without stacking is going to the amount of $27,885. But this is a large farm, and I commend Mr. Singh for being a good entrepreneur and being a large farmer now. But with that comes a factor of 0.7, which we could consider if we so desire, in which case the penalty would be $35,490. What is your pleasure?
Dr. Longley, I remember this matter when it came before the board or before the panel in Fresno. And I remember the testimony by Mr. Singh and the office manager, and how she had been maybe quietly suffering from her illness for a while and was trying to stay afloat, and to the degree that she had fallen behind was not really revealed until after her passing. So I think that that was considered. I think that at that time the 0.55 was used based on consistency, and I know that now we're taking a different look at it, which I'm open to, but certainly the stacking is important. So I think that Mr. Singh recognizes that there was a responsibility that was neglected. I don't think that it was intentional. I do think that there should be a penalty. I think he knows that there's going to be a penalty. The question is just as to what dollar amount. So I would make a motion or support a motion, if there's no more discussion, that I would make a motion that we impose a penalty, that we modify the ACL recommendation to reflect the stacking issue that we've been discussing, leave the farm size at 0.55, or is it 0.55? .55 and issue the penalty in the amount of $27,885.
I would agree with that.
Can I ask a question? So the cleanup and culpabilities are at, and that number are 1.3, 1.3, and 1.0?
That's correct.
1.3 and
Or 1?
I believe they're both 1.3. So your cleanup and cooperation is 1.3, and your culpability is 1.3 in currently in the
So
calculation.
to me, the more consistent approach would be to make it a large farm at 0.7 and do 1.0, 1.0, and 1.3. I mean, I'm probably not going to change the numbers a whole lot, but from a consistency point of view.
It gets to the consistency issue.
The days in which this facility complied was still more protracted than the two cases that came before you earlier, by, I believe, about a month, month and a half, which is fairly significant considering that only happened after the ACL complaint was issued and after the enforcement proceedings were well underway. And those dates were not affected by the office manager. So again, just for the board's consideration, I do think that the 1.3 perhaps is more supportable in this case as opposed to the other case.
Okay.
Quite frankly, I'm for, because this is a larger operation, going to the larger factor of 0.7, and I can't support the motion as it stands. That's fine.
I'm also in agreement with you,
That's
Dr.
fine.
Longley, on the 1.7.
Well, do you want to go ahead and make a motion, Carmen?
I've made a motion, I believe it's been seconded, so I think it's either going to succeed or fail.
It's for the 26.
Yes, 27,885.
27,885.
And I had seconded it.
Okay, and it's been moved and seconded. Carmen made the motion, Raji seconded it. Call the roll, please.
Ms. Brar?
Yes.
Ms. Ramirez? Mr. Costantino?
I heard you call my name. I'll say no.
There are, in fact, a number of changes that need to be made to this. I would suggest that
Well,
before
let's
we
finish
complete the
let's,
voting.
let's finish the roll.
Okay.
Keep going. This is interesting.
Dr. Markham? Ms. Kadara? Dr. Longley?
No. We got a tie vote. Motion doesn't carry. So let's see if we can get concurrence on something here.
I'm not opposed to modifying the number to reflect the 0.7, if that is what seems to be. I mean, it's so if somebody's interested in making that motion, then I could find a way to support it.
So I would make the motion that we amend the factor from 0.55 to 0.7. I'm not sure what that number turns into, but leaving the cleanup and culpability at 1.3.
And that number turns out to be 35,490.
So that would be my motion.
And we could put that in front of the board. Andrew's worked up the draft of this, so we can put it up within a minute in front of the board.
John's made the motion and Denise seconded it. Yes, and please put it up in front of us. And I have to thank all present for their patience as we work through this. I think we've done a pretty good job of seeking justice as we look for consistency and consider all the factors involved.
And again, walking through in a much similar manner as the other one. Finding 18 is where the modifications start. That reflects the number of days based on a submittal of the second of two farm evaluations. That's the last one that was past due as of 26 September 2016, consistent with testimony received in front of the hearing panel. Finding 22 is modified also to make that consistent. Finding 26, the maximum penalty is lowered, again, consistent with the number of days between the first violation and the time the violations were rectified by the submittal of the second farm evaluation. The typo on finding 29 is corrected to reflect that we're here in 2017. Final administrative civil liability amount is $35,490. Moving further down into the calculation, again, multiple day violations. The text after that bolded line is changed as of 26 September 2016 when the discharger submitted the 2014 and 2015 farm evaluations. These farm evaluations were 574 days past due. That was actually the second of the two that was submitted on that date, but they both became, the problems became rectified when that second of those two was turned in on that date. The compression under the enforcement policy calculation can go to 25 days. The board chose 30 days. Again, that's consistent with the hearing panel decision. 0.7 factors used. The initial liability amount goes from $16,500 to $21,000. Moving further down, this is where the big downward change happens. Instead of charging multiple violations, it's just a single violation of a failure to submit farm evaluations, and the adjustment results in a liability amount of $490, sorry. And then one more change to the maximum liability amount and the final liability amount. And that's the proposal.
We have a document in front of us then that was prepared by counsel that represents the motion that was made. And is there any discussion? Hearing none, we will vote. Call the roll, please.
Ms. Brar?
No.
Ms. Ramirez? Yes. Mr. Costantino?
Aye.
Dr. Markham?
Aye.
Ms. Kadara?
Yes.
Dr. Longley?
Yes.
Motion carries.
Thank you very much. We'll now go to item 17, Victor Produce. This is the time and place for a public hearing to consider administrative civil liability for order for Victor Produce of Merced County. The designated parties for this order are as follows: the board's prosecution team and Victor Produce. All other parties are considered interested persons. On November 2016, a hearing panel of the board considered an Acl complaint issued by the board's prosecution team. After receiving evidence and testimony, the hearing panel adopted a recommendation that the board issue an Acl order at a subsequent meeting. The board will now consider the hearing panel's recommendation. Though the board will not be accepting new evidence, the board will allow designated parties and interested persons to make brief policy statements. These policy statements may not be used to introduce new evidence. The following time limits will apply to the policy statement presentations. For the board prosecution team, Victor Produce, and all interested persons are allocated 3 minutes for their statement, and a timer will be used. All persons expecting to testify, please stand at this time, raise your right hand, and take the following oath. Do you swear the statement you are about to give is the truth? If so, answer, I do. Thank you. The order of this hearing is as follows. The board's advisory team will give a short presentation describing the hearing panel recommendation. The prosecution team, Victor Produce, and interested persons will then be permitted to make their brief statements. Please state your name, address, affiliation, and whether you've taken the oath before testifying. If you haven't submitted a speaker card yet, now is the time to submit one to Ms. Lanfranchi Rosardi. Does Regional Board Advisory Team Council have any legal issues to discuss at this time?
No, Dr. Longley.
Are there any procedural issues that the designated parties would like to raise? Seeing none, we will proceed with the advisory team presentation, and we will begin with the advisory team presentation. Excuse me. Go ahead. It's getting late.
Good evening, Mr. Chair and members of the board. My name is Adam Lapitz, Assistant Executive Officer here in the Rancho Cordova office, and I have taken the oath. I'm going to present a summary of the hearing panel recommendation for proposed administrative civil liability for Victor Produce of Merced County. Victor Produce owns approximately 271 irrigated agricultural acres of sweet potatoes and almonds. The East San Joaquin Coalition order was adopted in December of 2012. Victor Produce enrolled in the East San Joaquin Coalition in February of 2015. The East San Joaquin order requires all members to complete farm evaluations. For members within high vulnerability areas, farm evaluations are due annually. Because Victor Produce enrolled in the coalition late, or at a later date, only one farm evaluation is being charged as a violation here. And it was due in March of 2016. In summary, the discharger failed to submit the farm evaluation for 2015. In May 2016, a final notice of failure to submit of the 2015 farm evaluation was sent. This was after a number of coalition outreach attempts. Acl Complaint was issued on August 8th of 2016, and the submittal date of the farm evaluation was August 25th of 2016. The maximum liability amount was $160,000. This is for 160 days of violation, which was compressed under the enforcement policy to 20 days. The proposed liability amount was $15,210. After consideration of the record and testimony at the panel hearing, the hearing panel recommended an amount of $18,590. This was adjusted based on increasing the per day factor from 0.45 to 0.55. The November hearing panel recommended that the full board adopt an ACL order in the amount of $18,590. All three board members present voted yes. Thank you.
Any questions? Okay. Ready for testimony from the prosecution team?
Dr. Longley and members of the board, Andrew Altavogt, Assistant Executive Officer in the Rancho Cordova office, and I have taken the oath. And I just want to say on this one, we concur with the panel's recommendation.
Questions? Mr. Baca.
And again, thanks for sticking it out.
You have a lot of endurance.
My name is Gilbert Baca, Sales Manager, Victor Produce, 14588 Atwater Jordan Road. Oh, and I took an oath, yeah.
Thank you.
I really don't have that good of an excuse, except for the owner of our business was in New Mexico, so he kind of had me, who was a sales guy, and an office manager who was doing this stuff. So the office manager wasn't too familiar. She actually was the one that signed us up in the coalition, not even the owner. So it was a little iffy and unsure how to do some of this stuff. Eventually, she gave it to me, which that's when it, everything started coming in. I started working with, I talked to somebody named, I can't think of her name, Sydney. Yeah, anyway, so she kind of helped me. And so far we've been, I just want to point out, there was nothing wrong with anything as far as our farm practices. It's just, it was a filing issue, and that's been handled. I do it solely now. Been going to water meetings and all that kind of stuff, trying to learn, so no good excuses, but that's what it is.
And you feel you're up to speed and you're going to be in compliance moving forward?
We're definitely in compliance. I don't know about up to speed, I'm learning. But I just asked a lot of questions.
That's a tough question to ask. Okay.
Is that it?
Yes.
Thank you.
So are there any questions? I guess not.
Only, do we have any of the issues we've been dealing with in any of these other?
Well, let me check. Interested persons, seeing none, we will close the hearing and confine discussions to the board members and the advisory team. One of the issues here is that Victor Farms enrolled late. And the farm evaluations were not submitted. And if they had, we could recommend that this issue be reconsidered because they rolled late, but I've been told that it would not change since they did not receive a 13-261, and days cannot start until it is received. So that's not a direction to go. I'm concerned that this penalty is not even a slap on the wrist, but it is what it is.
Dr. Longley, if I can, to me,
Sure.
for the board, and I just have to be honest here, it's sending such a wrong message. It's reinforcing for members to not file, because if they don't file, they don't have to submit late reports, and if they don't submit late reports, they don't get penalized for it. And so it's an economic benefit for them. This penalty this low is sending a strong message. I'll just wait till they catch me, because this is really shocking to me that it is the lowest of all the penalties for the non-filers, and the ones for non-reporting. So this one is reinforcing some of those coffee shop comments that we'll just wait and see what happens.
And also, there has to be that consistency that we're talking about. And I mean, I just don't understand what happened here. And maybe if you guys can talk about the hearing and how you came to this.
So if I could, I think that with respect to this violation, I think the board at the hearing was receptive to the prosecution team's argument. In my legal opinion, the toughest thing about the Victor Produce case is both the way the water code is structured and the way the enforcement policy is structured. The enforcement policy does not give the board a real easy alternative to assessing liability to somebody who should have been enrolled in a program, was not enrolled in a program, and then barely by the deadline gets enrolled and then says, well, you know, those earlier violations that I should have been accruing had I been enrolled, those don't apply to me because I wasn't enrolled. And it's really, it's difficult in that there really isn't a metric to capture that in either the water code or the enforcement policy. I think the one avenue that presents itself, should the board believe that this is a violation, or this is a violation that, given those circumstances, merits a higher penalty, would be in reconsidering the amount of days that the board charges for the violation. The number of days that Victor Produce was out of compliance with that one submittal is 160 days, making the maximum penalty $160,000. So the board has quite a range. It does not have to compress violations down to the minimum or to a number anywhere near the minimum. And if the board was so inclined to assess a higher penalty, the avenue, the most readily available legal avenue of doing that, would be to increase the number of days of violation that are charged on the basis that that captures the situation that the discharger was in that they were wholly not enrolled, and therefore the requirement to submit the earlier farm evaluations didn't apply to them because they were not enrolled.
Have you investigated that further insofar as calculations?
Frankly, it would be a fairly rough calculation. The board would deliberate and, in its judgment, arrive on a date that the board feels serves as an appropriate deterrent for this type of behavior. And that number of days could be anywhere between the minimum and the statutory maximum of 160.
And the minimum is how much?
The minimum is 12 days. They were charged with 20 days.
12, 20, and 160.
So, Dr. Longley, just for reference, if you start at 20, what we have is 18,590. At 30, you have 27,885, and at 40, you have 37,180.
And I have a question. We're talking about size of farms. What did you use that? What number did we use in this calculation?
This calculation was a 0.55. That's an astute observation. This calculation was based on a 0.55, and this farm is 271 acres, which would be on the larger size.
I think that's something we need to address. We can't just arbitrarily pick a number, or, that has to be some more discussion on what's a large farm, what's a small farm. When do you use 0.77, when do you use 0.55?
And to be sure, it's actually a range between 0.4 and 0.7, so it could just as easily be 0.6 or 0.45.
Well, we've used 0.7 for others, so what is that calculation? It should be on the order around 24,000.
So if you use 0.7, it's 23,660. That's with 20 days compression. That's the amount that was in the recommended amount.
Glad we have an engineer up here.
So when you say use 20 or 30 or 40, those are the compressed days.
Correct. So what I gave before was just a amount. If you increase the compressed days to 20, 30 to 40 based on the per day factor of 0.55, I can do that again at a per day factor of 0.7 if you like, also, to give you a sense.
And so it was 100 and what was the total number of days?
Total number of days in this case was 160.
And that compressed to 12?
To 20 was originally compressed to 20.
The minimum value under the compression formula is 12, and then the board has discretion to pick any number between 12 and 160.
And 30 days, if I'm not mistaken, is 35,490, which is a number I've heard somewhere before today, I think.
Yeah, that was the previous.
Right.
I'm inclined to focus on the egregious violation of deferring to sign up. And I know that there are farmers out there that just figure they're going to pay the penalty later on. So I'm in favor of a significant penalty, 80 days.
It would send a message.
Yeah, I was more in the 60-day range, but that number is, to me, that's 60 days. It's 2 months. That 90 would be somewhere in there, but I don't know how that works. That's not really a compressed number. To me, that's the real number, not a compressed number. But I guess you could keep the real number.
Well,
Just if I could, as a point of reference, for somebody, the board earlier today considered the Bath ACL and arrived at a number for 473 days of not signing up to the coalition, not submitting farm evaluations, not doing anything that they were supposed to because they were not signed up. That number wound up being 35,490. Very similar sized farms. That farm was 289 acres. This one's 271, growing similar type of commodities. Cleanup and cooperation scores of 1.3 and 1.3. So I would suggest that is the completely not following any of the board's directives for a farm of about that size. Perhaps the somewhat following the directives and signing up very late, submitting one farm evaluation late, would perhaps fall a little lower. Again, just to give a very ballpark number about where the board's prior decisions were indicating.
Well, as I stated earlier, using the 0.7 number and 30 days, compressing to 30 days gives 35,490.
I still think it needs to be a little bit higher. I'd go along more with what John said.
Yeah, thank you, Patrick, for your perspective. I'll leave it at that for a second.
Well, 40 days is going to be on the order of $42,000.
So Dr. Longley, since I sort of started this because of my claim, but Patrick made a good point. We still have some who submitted 0 and they submitted really late. And I think when all this is said and done, we'll have a conversation with the prosecution team on philosophies and policies towards this. But because I don't know how the board can get at this for those who don't file and don't submit the reports. They seem to get an economic benefit from that. So in thinking of what we did earlier for just the non-filers, the board chose not to up a lot of them because they didn't file reports. I think we have to have a little, to make this one who did file finally, and then submitted only one report, or not one report they were due they didn't submit. I think the board should consider that as well, and how they come down to the total number of days that they compress to.
And again, my suggestion was simply to put a real rough ballpark on it because, again, mentioning the Bath ACL, there was a bit of a language barrier, other types of factors in mitigation that the board considered. And again, as I mentioned earlier, these decisions aren't binding precedent upon the board. The board can weigh these very, very subtle factors slightly differently, and can weigh these factors slightly differently in each individual case. So again, you have a lot of discretion in terms of how you weigh the factors in this, and I know it's been a very long day.
So I feel that it's appropriate to consider this case within the group. I think it's fair to treat this case in a way that would be consistent or similar to the types of cases and outcomes that we've been dealing with today. Having said that, I feel strongly about something that Board Member Constantino said, or maybe it was another board member, but that this is the beginning of the program, and that these types of oops, I didn't know, or whatever, would not be taken the same way later in the program. So just because there's an outcome that was maybe fashioned in November and maybe ratified in February, doesn't mean that the next person that we see would get similar consideration, because this is somewhat of a evolving and I guess there's a learning curve to the sophistication of the program, and sometimes that plays and sometimes it doesn't. In this case, I'll leave it there.
I think what Patrick had to say for me, I'm comfortable. I think that was a good comparison as far as bringing up the other case and the size of the farm and the non-filing. And I would be comfortable with sticking with that number. And I think Chair Longley had mentioned that as well.
That's the 35,490, which is 30 days and 0.7. So
I think it ought to be 40 days.
40 days would be 47,320. 35 is 41,405.
And what's 30?
$35,490.
So I am going to make a motion that the hearing, that we adopt aspects of the hearing panel's recommendation and issue an ACL order for a different amount based on the farm size to be a 0.7 and the days of collapse be down to 30, rendering a penalty amount of $35,490.
And I would second that.
Carmen's moved and Raji has seconded.
We would need to put this up on the screen too, and
We'll get a minute standing in place. It may take you more than a minute, I know.
this one, there's a lot of moving pieces, so it may
Okay.
be a
Please
couple
put it
minutes.
up on the screen and we'll stand in place while we wait for your outcome. My spaghetti's, well, we'll forget that.
Andrew says he's almost done.
Dr. Longley, wouldn't we want some kind of indication of whether or not these numbers are going to be supported by the board before council does all this work? Because if the motion's going to die, then. Okay, all right, never mind. Never mind.
set when you're ready. Pamela is.
We're back in session, and we have the proposed order up in front of us.
Pamela is not here.
You'll walk through the
but
order, please.
I imagine it'll be a treat if we're done by the time she gets back. Walking through again, and again, thanks to Andrew Deeringer for working these up. The hereby ordered changes in this case to $35,490. And this does not have the changes to the other findings because there's no stacking that came up in this case. Walking through these, potential for harm, deviation from requirements stay the same. The multiplier is at the top of the range at 0.7, resulting in an initial liability amount of $21,000. And the days also change from 20 to 30 to get that $21,000 number. Culpability and cleanup and cooperation remain at 1.3. The total base liability amount is $35,490. The maximum and minimum, again, stay the same. And the final liability amount reflects the $35,490. And that's the motion that's on the table.
Any discussion? Call the roll.
Dr. Markham?
No.
Ms. Brower?
Yes.
Ms. Ramirez?
Yes.
Mr. Costantino?
Aye.
Ms. Kadara?
Yes.
Dr. Longley?
Yes.
Motion carries.
Thank you very much. We will be recessed.
Can I ask a question about tomorrow?
Go to-
Tomorrow's agenda?
Yes.
So we're starting with 18, and then we have, which is what we delayed from today. Then we have the executive office report, state of the region, and then closed session. Uncontested items 26 and 27 are now uncontested. Is that right?
That's correct.
And then we have 28 and 29. Is that right? Okay. Okay, thank you.
John, do you want to see something here, which may help you a little bit? Yes, sir.
Yeah. You need to say adjourn.